Give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me back on pussy. One sip, two sips, and I'm feeling so alive. Coffee in the morning, it's the best way to survive. Woke up in the morning, sleepy eyes yawning. Jumped out of bed, started the day, opened the curtain. Felt the cool breeze, the sun shining on my face. But something was missing, I needed my job to chase. Give me coffee in the morning, give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me back on pussy. One sip, two sips, and I'm feeling so.
Good morning. Good morning. I'm here, but barely here, but I'm here. Welcome in Butterfly. Welcome in Dolphin. How are you this morning?
I'm better. Yeah, I'm better. I just
You
want to
sound
be
better.
done with this cold, you
I
know.
bet. Yeah, you're over being over it now. Uh,
Mhm.
You do sound a lot better though. So
Yeah,
that's
thank
good.
you. I have some laundry going, and I ate a couple of egg rolls. So
Oh my
yeah.
gosh, I'm usually up like at 4 a.m. and guess what? I haven't been up very long at all. I woke up once and I was like, oh, I got plenty of time. I went back to sleep and I woke up. I was like, oops, I better get up right now if I want to
Mhm.
be on time. But so yeah, here we are. I got to go make my coffee. That's how behind I am. I'm usually 3 cups in by now. Um,
I could use some hot tea for my throat, but yeah,
yeah, I'm
I've
ready
been
for
up
some
for
coffee.
hours.
I usually have been by now, but anyway, I'll take it. It don't matter. I sleep when I sleep, right? And I slept, so it's all that matters. Um, So I'm looking forward to today because you know what? With it being Friday, right? It is Friday. Um,
Mhm.
the defense gets to do their opening, and then the jury can sit there and marinate on that shit all weekend,
Oh
right?
yeah. Yep.
Um, and if the because when Karen left court yesterday, she told reporters who the first witness should be today. And a lot of people heard it, and a lot of us I saw were looking that shit up last night. And what I saw from that guy, I was pretty impressed with his credentials. And I found that video that he was talking in. I listened to him explaining some of the things that he does. And I
Mhm.
thought, oh, good, this is going to be good. So
Yeah.
I hope it is, um, because he's going to talk about well, some say he's a phone data guy, but
Mhm.
that's not what his information says. The other witness is the phone lady, Maggie Gaffney, is a digital forensic examiner. This guy, Matt DeSorga, he should be an engineer in the event data recorders and even talking about damaged recorders. And we know that there was an issue
Mhm.
there. So this guy should be pretty good as far as talking about it, as far as going up against what the other witnesses, Burgess and Welcher, have said about Karen's black box and the miraculous recovery of the damaged SD card. Those are the things that were popping into my mind when I was reading about this guy and watching that video I found on him. I was like, wow, okay, maybe we can get somewhere now, with some, uh, not get somewhere, that's kind of the wrong way to put that, but just
Mhm.
to hear their version of what could have been, what reasonably
Yeah.
could have happened otherwise,
And
right?
after all of this mess with Dr. Welcher, I think it makes perfect sense for them to start with this particular witness,
Yeah.
so they can like stay on the same topic and then
Yep.
see the other, somebody else's opinion of,
Yes,
the data.
that's a good strategy to have, right? And
Mhm.
I was watching because I don't do a lot of the Karen Reed updates at night because I'm usually doing other stuff. But last night I ended up jumping over into Defense Diaries for a little while because then they had on that attorney Bettero, or however you say his name. Anyway, they had a really good conversation about some of that stuff and the what ifs and
Mhm.
the different witnesses they could present. And like one of Bob's thoughts was take the two ARCA guys and you just sandwich them, one at the beginning and one at the end. That way the jury remembers that the most, um, as far as their alternate theory that he didn't get hit by a car. He's hit, something else happened. And so it's going to be interesting. And do there is a more updated witness list out for the defense, but it's not much different than the one we looked at from that article that I had pulled up.
Oh, okay.
They have quite a few witnesses to move through. Um, so it's going to be super interesting to see how this part plays out. I'm ready for it, honestly. I'm just ready for it, this part of it. Looking forward to
Yeah,
seeing
me
this part of
too.
it.
hmm
Yeah,
Now that I can actually sit and, pay
right.
attention to the trial and watch it and,
Yeah,
and everything. And I think that this side of it, I want to see what they're gonna, because I don't really trust the Commonwealth so much
exactly.
and whatnot.
Mhm.
So now I'm like, okay, now let's see how the defense is going to,
That's where I'm at. Yeah, because
like
I've already,
counteract what they've done.
yeah, exactly. Excuse me, exactly. Um, because I think the state feels like they've done a lot of damage. They've attempted to do
I
damage,
don't
but I
know
don't.
why.
Yeah, I don't know. I think they've attempted.
hmm
Girl, yeah, they think they did, and apparently a whole bunch of people out there think they did as well. So, I don't know. Good morning, Sinead. Welcome in. 4 months member. Nice. Welcome in. Vixie, welcome in this morning. You guys come on in, get settled. They got the fan spinning in the courtroom still. They have not started yet. I was like, oh, I better get on before the court starts. It'd be bad if I'm behind Bev. That's saying something if I go and come late because I was sleeping. But
Oh God,
yeah,
I got a big old shock when I was looking at your intro and I saw a big, huge picture of Bev. I was like, oh, okay.
oh yeah, that face she makes, I couldn't help it. It was just
hmm
that face was like, I think that's classic for this. So I just stuck it in there. I was like, yeah, that kind of suits it. But she smiles an awful damn lot with her little giddy smile that she gives to people. And I'm like, I don't know. I like the what the fuck look better.
oh, Sinead.
Oh,
Yeah.
yeah. Yes. When life gets crazy, it's bad enough. Then this stuff gets even crazier. And it's like, you're like, you can't overload here. But at least this one is the painful part may be over, right? Because I already knew what the defense, or I knew what the prosecution was going to come out and say, but I didn't know how well any of that was going to land. And it didn't land well at all. Not with me, anyway. They had too many shady witnesses and things of that nature, and it's a whole stack of stuff. Let's just put it that way. I think most of you know that by now, but it is a whole stack of stuff. Um, and when combined, it's like a lot. So um, I do have,
Yeah. I've almost gone through this box of cold medicine. The daytime, I think
yeah,
I have one more packet to take. Haven't used the nighttime at all, but yep.
yeah. Mm, I I could need to go make my coffee for real. I'm just realizing I still haven't had that. I'm like I'm still kind of half asleep. Um, So I saved Sleuthy's spreadsheet because she updated it. I think it was yesterday. I mean, I've had it all along, but I went back and revisited it because I knew she updated it. But she's added exhibits witness list from this trial to the spreadsheet now. So that's super convenient. Shout out Sleuthy as usual. Fantastic job because all I can do is go there and click a button and pull up what I want. Fantastic work.
Yeah, she
I'm
does
I'm a
create
little
nice
girl, I'm so
spreadsheets.
jealous. I don't know how to do that shit, and I don't wanna
hmm
try. I don't wanna it's like,
I
that's what
took her Idaho one and started like, making some slight changes, but yeah.
yeah.
And it needs to be updated. So
Oh,
I
yeah.
was like, well, let me maybe start working on updating it.
Was she backed out of that case, a long
Pretty
time.
much when he got indicted.
Yeah, well, she kept some stuff on Twitter for a while, and it she did some videos and different things. It took her a minute, but she did back off of it for a little bit. That she just dove head face into Delphi, and That case took a lot out of a lot of people, and
Mm-hmm.
she poured a ton of work into the Delphi case. She and All Eyes of Delphi, actually, they got some amazing work spreadsheets done in those cases. So she's now back to her Karen Reed. I feel like if she feels like there's something worth with the Koberger stuff, she'll be back at it. But so far, she's just like, you know, nothing to see here. I don't know. But her spreadsheets are amazing. Her work is good. It takes a long time to collect all the information and organize it and get it as neat as they do. It's always helpful, and I do appreciate it. Now, Miss Lori Vallow ended up having two hearings yesterday. They're still doing jury selection today. I think yesterday was questionnaires. Today they're questioning the jury in person, kind of thing going on, voir dire. But she ended up with two hearings yesterday, and one was before a different judge because she wanted the judge Boreski to recuse himself. That judge did not agree with Lori's um, findings in her motion, so they denied it, of course, so Judge Bresky got to stay on the case. Then, yesterday, after they were doing their jury selection, they had to have another hearing. And boy, the fireworks flew in that hearing, too. Lori wanted to be all pop offish with him, and he's just done with her, you can tell. He's like, you done tried to recuse me, not once, but twice, and accused me of things, right, that ain't true. So, lady, I'm done with you. He was short, to the point. He made sure things were on the record. I've got the hearing. So it was interesting to say the least. But they should wrap up that stuff here. I think they got this trial over there slated for June 2nd, which will be the final chapter of Lori Vallow Daybell, hopefully. And maybe finally all of her victims will finally receive justice, and she can take her happy ass into the corner and sit down with her slop. Because, yeah, so over that damn lady. But yes, so that's what's going on there with that. Little updates on those two things. So they're still got the fire. I almost said fireplace. The hell's wrong with me? No coffee. That's what's wrong with me. I can't even talk. Don't know my words.
Yeah, I do want to get up to go get some tea, and I just saw a deer set off my cam again.
Oh,
Just
nice.
standing square in the middle of the patio. I was like, okay, just standing there staring, like, you gonna feed me at some
Yeah,
point,
they're
lady?
they're done got used to you. They're coming. They're
Mm-hmm.
done
Yeah.
used to it. They're coming for that breakfast.
Yep, they'll probably be at the front door too. But yeah, I will probably put something out there. Actually, you know what? I'll be back. Let me just go sneak something out there real quick because I
You're
do feel
fine. Go
bad.
ahead. Go
And
ahead. I
I'm
get
gonna
it.
heat up some tea too. Okay.
You're fine. Go ahead.
Okay.
Yeah, when they start the hearing, or I keep calling it a damn hearing, when they start this trial in a few minutes, if they start it, I'll make my way to the coffee pot and put me some coffee on. Got my grandson's home. School's out officially here. School is out. He is asleep. He's taking advantage of not having to get up early and get out of this house. Yeah, Butterfly, she says she messed up. I don't see her being flexible and him being flexible with her anymore, right? You could tell. Um, I had Joe and Crescia were doing their live, and um, I was literally all over the place last night. Pokemon knows because she saw me everywhere. We kept running into each other at these different YouTube streams, but so I got over there to Joe's, and at the same time, they were watching the hearing. I'd already watched it, but I was in there watching with them, and at the same time, Joe and I said the same thing about that. He's done with her. You could It was so obvious from the hearing. So I was like, "You owe me a coat, Jinx, Joe. You owe me one," because at the same time we both called that shit. It was just so obvious. He's like, I'm not even gonna argue with her," and I think there was a court filing that came out where he talks about how he didn't want to argue with her, and she didn't seem to understand, you know, whatever. But anyway, yeah, he's not playing with her anymore. And good, because I'm tired of watching people play with her, right? Don't play with that lady because she's not playing with y'all. Well, she is in a sense, but you know what I mean. A crazy lady, wacko. You listened to it for a little while, Butterfly. It was a pretty good stream, and it was nice to see my thoughts kind of aligned with theirs. I was like, oh, maybe I'm not so wacky in the head after all. It was a good live. The last live I think that I went to was Allie with Melanie Little discussing the case. Because I don't usually go into the Karen Reed stuff a lot at night. I'm doing other stuff with other cases usually at that point, but it was an interesting conversation to get their perspective on things of where they think things sit, and even theorizing on how things may be handled moving forward with the defense and how what they would have done and done differently. Things like that I kind of enjoyed that law aspect of it. That's why I'm watching them, right, to get that part of it. And I don't watch too many of them out there because a couple of them I will, but not all of them. And who doesn't love some Ali Mata, right? Such a down to earth woman that you can relate to. Well, here's the thing, Butterfly. I made a statement last night in Joe's channel, or Joe's stream. I think that after Brandon's trial is over, I need to have a ceremony and once and for all and safely close the freaking portal. Because that portal's not sucking me up, right? And it ain't letting all that negative energy and bad entities in because that bitch didn't know what she was doing when she opened her portal. So someone needs to come and close that thing up, and I might be the lady for the job. And if the rest of people start falling down that portal once she's gone, that's all on them for doing it, right? Yeah, Allie is great. It's hard to find somebody who is super intelligent and knows what the hell she's talking about, but at the same time, you get that everyday lady feel, right? That everyday woman feel, that wife, that mother, that everything. It's all wrapped up into Ali Mata, and it shows, and I love that about her and her dead ass honesty. I love a good, strong, honest woman, right? Oh yeah, girl, we can do it. We'll get us some holy water and all kind of stuff going. Bye, bitch. That's what part of their problem. They didn't open their portals safely to start with, because Zulema and the gang didn't quite know what they were doing after all. I don't know what's going on inside the courtroom. We still got the fan spinning. I'll refresh it and then see. Yeah, there's still a fan spinning. I don't know if they had something to take up this morning. I feel like there's always something they want to take up before the jury gets brought in. And then once they take that up and bring the jury in, we have to go to automatic sidebar. But it's automatic Friday and I feel good, so what the hell ever. Vixie, God, girl, I got some sage too. We'll do a damn live stream and combine our efforts. How about that? We can combine those. I might need some backup, and Vixie, you just might be my girl. We need to close that portal up and close it up tight, right? I feel like it's sucking some of my friends down in, and they might not come back out. Joe, are you okay? I think Joe is going to make his way down there today for the voir dire of the jurors. There's some interesting facts that will come out in that case, so it's going to blatantly show Lori's conspiracy. I don't think it's going to be hard to get that trial to get that case to a verdict, and it's not going to be a long trial. And Lori is so going to add that appeals to her other appeals. We know appeals take forever, so Lori's got plenty to do. Plenty of work to be done for Lori. All right, guys, they're coming into the courtroom. I'm here for it, so I'm ready to get it on.
Now open initiative.
Oops.
So I was told council want to see me at sidebar?
Of course. Of course. We're still not happy. We still can't work this stuff out, ma'am. We still need you to figure it out. So apparently, they're trying. Karen said yesterday they don't know how else to get Trooper Paul's testimony in, basically, without calling Trooper Paul, because every time they try to get it in through cross exam or anything, they're interrupted, right? And they're not allowed to do that. And I don't know if there was a preconceived thing, because I know there were some things they were just not allowed to talk about, and I don't know if that was one of their, but that's goofy to me. If so, this is your main guy from your first time around, so um, I don't know how some of these people they need to call just to help establish more of their reasonable doubt, not to come in and prove that something happened in that home, but to establish more of the reasonable doubt that he was hit by this car, which leaves you one option: something happened in that home. Reasonable doubt's been laid a little bit with your through cross exam, in my opinion, enough to intrigue me. Like if I'm a juror, didn't know shit, I'm intrigued by some of the things the defense brought out at cross examine, right? And I'm making notes of those certain things. So I'm so ready to get their witnesses going for sure. Sidebar number one of the day. I forgot to keep my running tally of every day how many sidebars there were having. We could have tallied it up at the end of the trial and see which day had the most sidebars. We'd probably be shocked at the numbers. If we, actually look at it on paper and go, holy shit, that was a lot. Doesn't Karen have a brother? Is he like at the courthouse? I don't have no clue what that man looks like. Hell, I didn't even know what John's family looked like until this trial started. Yes, thank you, Butterfly. Please come on in, everybody. Grab your coffee, your tea, whatever your vice might be. Get comfy and get your popcorn, whatever you need to get. Your jar of gummies, your whatever, your mimosas. I don't know what y'all be doing out there. Do you? But come on in and get settled. It should be interesting. Lord, I feel weird. I don't have a cup of coffee in front of me. I've got to go get my coffee started. I feel so thrown off this morning. Oh, wait. I need to change that.
Okay, I'm back.
Oh,
Oh,
you're
they
good.
started?
Well, they are, but they're immediate sidebar.
Oh, great. Uh, so I went out and she was on the other side of my car eating some leaves off of some bushes, right? And then so she kind of went up the hill a few feet behind the bush, like that was hiding her. So I went and got the food, and I had a big bag, and I dumped it out there, and I called her, and I was like, blowing kisses at her because they turn their head at that sound when you go like,
Yeah.
you know?
Mhm.
And so I was like, hey, pretty girl. I was like, come eat, right? So she heard me drop it in there and everything. And I saw her peeking. And then so I turned and I came back in the sunroom and, I closed everything up. As soon as I get back in the den, I turn around and Pipsqueak's looking at me like, she was
Jealousy.
like, I heard you,
Mhm.
like that kind of look.
You're
And then I
you're shit for the rest of the day now.
Okay. Yeah, she's in the den. She's not even in the office with me anymore, right? So I looked out the windows again, and yep, she came right down the hill as soon as I walked back away, and she's out there just having a good old time.
Good for her.
Hmm.
Pipsqueak's like, "I'm not having it, lady."
I know. She just gave me that sideways tilt, beagle tilt, and just looked at me
Uh-huh.
like, ugh,
Yeah, I
you
see you.
know.
I see you, mama.
Yeah, I was like, ooh,
Pixie got
yeah.
salted caramel coffee. I love a
Oh,
good
okay.
salt. I know I love a good salted caramel coffee. I do. I do have some pretty interesting flavors in my refrigerators. Maybe I'll make me a
Mm-hmm.
fancy coffee at the house today. I got cold foam as well. I can make it happen. I don't live close enough to a fancy coffee shop. Well, this one little we have one ridiculous little restaurant in this whole entire little community. And food's mediocre at best, but it'll do. But they have a little Starbucks in there, and they had to learn how to make Starbucks, right? It wasn't like your ordinary Starbucks. It's weird, hard to explain.
Oh boy.
But
Mm-hmm.
yeah, I've gotten a coffee there a couple of times. Only once was it really good, right? So I'm like, I'm forget that place. My favorite place is way down deep in town, and it's not even worth the drive for a damn coffee because it would take me entirely too long, and the coffee would be gone by the time I got home. So it's like whatever. So I buy my own stuff and make them at home.
Mm.
Yeah.
The whole time we were on our trip, Crystal was like, I need coffee. I was like, oh my gosh, well, you're in the right place for it.
Oh god, if they didn't have coffee at a place I was going to, I'd have to bring my own. Are you allowed? Because I'd be like, y'all don't have coffee? I cannot go. That's not that's not even debatable. I don't care if it's shitty coffee. Do you have coffee? I would be doing the same thing. If you're a coffee drinker, you can't go
Mm-hmm.
without it. Hmm.
Yeah, I bought some tea while I was there. I haven't tried it yet. I'll wait till I get my taste buds back 100%.
Yeah.
I bought it from a monastery,
Oh,
sold
nice.
by a nun. Oh yeah, wait till you see the photos of these monasteries. We drove 4 hours north of Athens to this place. It was the Holy Trinity of monasteries in Meteora, and there are six different ones there, like five and a nunnery there,
Mhm.
and it's just all up in these mountains, and I mean, gorgeous. Actually,
Picturesque, right?
yeah, I should be able
It's
to show you guys a photo.
I bet it's, like,
Since they're
super
just
relaxing. I'd probably just stand there and go, "Heal me." Heal
well,
every
driving through up there was a little nerve-wracking, but
Oh, I can imagine, right? The little
Let's
rugged
hmm
start with
terrain.
the required finding argument.
Uh-oh, something about a required finding in an argument.
So I'll hear you whenever you're ready, Mr. Jackson.
Uh-oh,
Sure.
Mr. Jackson's coming to the podium.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think
Whoa.
that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven. to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scortibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there was not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once, she saw it pull up twice, she saw it pull up a third time, and then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed, and she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind it. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who is the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. A reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just 2 of the cornerstone pieces of intoxication which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus from her shattered right taillight that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypotheses about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments. On the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Mr. Yannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan?
I'm ready.
Okay, so,
Thank you.
all right, so we'll bring the jury in. That will take 5 minutes, Paul? All right, so we'll take a recess.
All rise, please.
Well. Well.
That was quick.
Mm-hmm. Okay, I had time to get my fresh coffee, though. Okay. Sorry, I'm getting my paper together here. Okay. You know, Nagel texts Julie at 12:23 I'm here. That places him in front of that home at 12:23. I'm still building my timeline columns because their timeline's not even adding up with certain things and what people saw or should have seen. Um,
Mm-hmm.
I agree with the defense. They failed to prove a lot. They've given you an idea of what could have happened, but an idea is not good enough, right? Not when someone's life is on the line and their future. It's never a good thing to convict on just those things alone. A lot of us could get caught up in circumstantial situations. You don't ever know. Wrong place, wrong time. Dixie says she can't wait for Arca and Dr. Russell. Yeah, those are going to be super interesting. The Arca people, absolutely, right? All those people are going to be super important to hear from. But I also want to hear from Higgins. Like, get this man on the stand. I had to hear all about how Karen's this and that and this and that. What about Mr. Higgins? Because if she wasn't hit by an SUV and I need to have enough doubt in my mind, and this guy may have been the guy, yeah, don't got to prove he did it, but you can sure come set that story up for me. I'm here for it. Obviously, the defense is super honed in on that, or he wouldn't have just got you talking about all that, right? And there was apparently Matt McKay. So I don't. Those of you who are in the chat that were watched the first trial, I did not watch all of Higgins' testimony. I've only watched a little bit of that testimony for out of curiosity, but I did not watch the whole thing.
Oh yeah.
So apparently, though, he has stated that someone did walk into that home that night, and it was a male person.
Wait, Higgins said that?
Yeah,
Oh,
but
interesting.
he didn't know who. He didn't say it was John O'Keefe. Like, he didn't know who it was. Like, someone did come into the home, but he's the only one that has said that. And I don't
That's
know.
interesting.
Yeah, it's very interesting, and so I didn't go back to watch all of Higgins' testimony either. But there's a multitude of reasons why they should or need to, not need to, but should call Higgins to the stand. I think if they want to bolster their their reasonable doubt, they're going to need to bring those people in to show the jury just how. Let me remind you how shady Mr. Higgins was, right? And let us point out his jealousies the way they were trying to point out Karen Reed's and making him to be the victim guy. Poor guy, he was being used by this vindictive woman. I think a lot of guys fell for that too, listening to that shit. And us women were like, wait a minute now. It's going both ways there in case you can't see it. Vixie, was that a slip up or is that proven? Because I've never heard. I heard all that hoopla about that Colin kid a long time ago, and I've thought it's like Delphi. Y'all need to pick a theory and stick to it, right? Pick a theory. So now you got a kid getting mad at John O'Keefe and doing what? Versus the two grown men that actually have a legit reason to do it, right? So did she slip up and say he wasn't in the house? From my understanding, testimony showed that kid wasn't in the house. But I also know part of the reason why I backed off this case a long time ago is I was seeing a lot of things on the social media streets. People were going after that kid hard and heavy, like her with harassment and stuff. And I was like, whoa, I don't even know why you would do that to start with, even if rumor mill at the time he was there and did this and that. I thought that was just a little much. So I just like, I don't like going after parents or children, and even if they're 18, 19, I don't know. That's to me is couldn't I just tear apart the Bryans and be done with it? I don't know. So I don't really know how Colin plays into all that, except a lot of people were saying he was there, he did it, he likes to fight, they're covering for the kid. Well, what the hell is Higgins all pissed off at John about then? If this kid, see what I'm saying? It's just a lot. Yeah, but you got two grown men who were just at the bar already a little agitated and going, doing their little throws at each other. I just have a hard time seeing this Colin kid coming up out of the blue and wham, as soon as John walks in the house. Makes more sense in my brain if it was Brian Higgins versus the Colin kid. So I don't know. He is, in my mind, honestly, he doesn't even play a part in this. I haven't even heard him talked about hardly at all during this trial, but I've sure heard enough about Higgins. Yeah, I don't know. I know his sister testified that he wasn't there. Somebody testified he wasn't there. She took him home. Was it Allie, his cousin, McCabe's daughter? I don't know if he was there or not, but he's not in the odd text message thread. So the people in the house covered it all up to protect Colin, because Colin was a little hothead. And the second John O'Keefe walked in that door, this kid just punches him. Nothing led up to that. That's where my mind was at. Like, why was he standing there? I got your back, Mr. Higgins. I got your back, Daddy's friend.
Jeez.
I got your back. I'll take down that man. I'll take down that big old ass Boston cop for you. No need to worry about that yourself, Mr. Higgins. I got you. Yeah, Allie said she took him home. That was Jen's daughter. Yeah, that's what I thought. Or somebody took his ass home. Is it? Yeah, I've had his too many things branches off there. These cases get to pop it off, and I do all of them the same way. It's kind of like with Idaho. At some point, I got 50 different scenarios coming at me. I'm like, y'all need to pick one. Because if you want me to jump down a rabbit hole and get on board with this shit, why don't
You are
have 50
unmuted.
theories? It's weird. Sometimes these cases have enough elements you could have 50 theories all at one time. Most of them, nah, one or two maximum. One theory should work. I don't need to branch off to 100, hoping one lands.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Kenobi, Justice of the Norfolk Superior Court, and for the country of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. Happy Friday. So I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. As you know, yesterday the Commonwealth rested, and as you know, the defendant has absolutely no burden of proof in this case, does not have to put on a case, but I hear that you are. So your first witness, please, Mr. Jackson.
Thank you, Your Honor. With the court's permission, we would ask that Matthew DeSoto join us.
Okay.
Bring him on, because I'm ready. I want to hear what he's got to say. I already know what he's capable of saying. Did my homework on that guy.
You solemnly swear the evidence you give the court and jury in the case down here is for the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good morning. All right, Mr. Jackson, whenever you're ready.
Thank you. Mr. DeSogra, could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DeSogra, last name Disogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction, and within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction,
Yes,
all
sir.
parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does EDR services mean?
So, event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing, so we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense, and as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please, finish.
Ultimately, anytime we're doing EDR or data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're.
So Lexus is a Toyota brand? Broadly.
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit, what about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so when we're analyzing that data, most of that's GPS-based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them, so we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is mechanism to figure out where on earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota/Lexus, versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say, how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle, then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems, and in a lot of cases what's important is quantifying that error.
So you're obviously familiar with GPS systems in many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead. The road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V, Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you've got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
And you have a Master's
Correct.
in engineering.
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed, in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you regularly attend symposiums or symposia? I guess is the right
Yes.
word. Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? I'm sorry. Have you attended data? Have you attended events that deal with data, event data recording systems, and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level, and then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am, active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I am currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization, within the organization of the Society for Automotive Engineers?
I am. I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does, and it requires, as far as I know when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year, published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components. It's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have an infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So, you know, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. We demonstrated we could basically do it ourselves if we wanted to.
Mr. DeSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval and recovery?
Yes.
How many times?
Once.
When was that?
In New York.
You were deemed qualified as an expert in that court in this field that you're talking about today?
Specifically with, as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes.
Are you familiar with Aperture?
Yes.
Before you were asked to undertake that review, were you familiar with Aperture?
Yes.
Were you familiar specifically with Shannon Burgess?
Yes.
Were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Ms. Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you, in fact, review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events, so we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming, that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event?
For the 1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds. 12:31:38 to 12:31:43, correct?
Objection.
Sustained as to form.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the jurors so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording, and as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Objection.
Sustained as to form.
Is there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that long.
That's my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long.
Right.
Correct?
Correct.
So in other words, it captures, or does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event.
Of the recording event.
Not
So,
the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate? I'll withdraw it. I'll ask it a different way. What would be the effect of timing if you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shannon Burgess's, the time offsets that you identified in Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Sustained, ask it differently.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question. With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection.
Sustained.
May we approach, Your Honor?
Yes.
Sustained. Objection. Sustained. What the heck? Oh. Ask it differently. That just like flat out just ask the question, right? I mean, I get what you're doing here. So the key takeaway is, even with Burgess, and I knew this guy was here to call out Burgess and his clock drifting bullshit. John's phone locks after the event ends. So after Karen Reed hits John O'Keefe, his phone somehow locks mysteriously underneath his body, flung up by the flagpole in the snow, along with thousands of pieces of busted up taillight. All right. Exploding taillight on top of that.
Yeah, she's annoying. I was putting laundry in the dryer and listening, and I just was like, wow.
Yeah, I was doing a couple of things and listening too. But I'm back at the desk now with my coffee, but damn. Let the man finish. We had to put up with
Ma'am,
this laptop
yes.
guy.
Thank you. Back to my question. Was there any circumstance, based on your review, that if the tech stream event occurred at 12:31:38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
Did you create a PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is no.
Following your presentation of the PowerPoint to us, at some point did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough, fair enough. Did that report, or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
Sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the differences.
In the first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
She's ridiculous.
After allowing all that bullshit from Welcher, she's going to be a little butthurt over the way he's asking a question.
Yeah, she's
Like,
just really ridiculous. And I could tell he's already annoyed.
yeah, I mean, don't you want your attorneys to be super damn direct instead of beating around the bush? And she's all like, no, ask it differently, ask it differently. The jury's not stupid, lady. They're picking up what you're putting down. So annoying.
Yeah, if this is the rate that it's gonna be, I may like get up and start vacuuming or
I
something.
just like, girl,
Put it on the TV because yeah,
I done got my house because I fell asleep because I got up late. My house got up late, I should say, is the way I look at it. But I got my windows open. I got my shit going.
mm,
I'm ready. But gosh, this trial's going to last another month, Butterfly says, at the rate we're going.
it looked like Alessi gave him a little pep talk on the way back.
Yeah.
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason and what was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I approach?
Yes.
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it. What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
Okay.
May I have that back from you for just a quick second?
208.
Thank you.
Your Honor, permission to display the PowerPoint presentation?
Okay.
Mr. DeSobra, can you still see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what is the how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide, what is this? What are we looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, I guess, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with, in Mr. Welcher's presentation that you disagree with? It's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
No, I'm going to allow it.
Well,
The phone interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So what
I'm sorry, Mr. DeSogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162-2 ends at 12:31:43, and they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event, so I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording, yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12:31:38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 123209 lock.
Okay. Let's go to the next slide, please. What does this slide show us?
So this, here what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, we have a lot of numbers to go through here, and so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please. What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
yes,
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all of the information comes from the Aperture reports collectively.
Okay.
From Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Yeah, so this is the first adjustment we're going to talk about that was, and this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment, and we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key, or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3-second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Ms. Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3-second delay? Or could that be different?
It could be different. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3-second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5, so we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3, and then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7. What are we looking at here?
This is an excerpt from Mr. Burgess's original report, his page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key-on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from, and that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned.
I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report?
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3-second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
in your opinion, was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask you to.
What, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point turn.
And where did you get that information from?
From the aperture reports.
In Mr. Burgess's original report, I'm differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as point 154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point, you said, was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure. I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So on this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but actually—
What do you mean sign conventions?
Sign conventions, he doesn't show when he calculates the difference whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a positive 5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it, and he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20, and when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes positive 6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and 0.154 on one table, and I calculated John's interaction window for all valid combinations from the aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data, rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the three-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the three-point turn data from the phone and the three-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support one point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the three-point turn?
He opines in that aligning the three-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess, in his report, indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into two tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a
So
continuation of
the
the
second half? So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my two tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct.
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is the continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay.
Just a continuation. Imagine in your mind is just rows 16 to 30.
Okay.
And it's the same thing, same format, except for now we're just adding in that key on adjustment because, again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees, and one of them, it's 0, again, simultaneous, and there are no negative values with this adjustment.
Can we go to the next slide, 16, please? What are we looking at here?
This is the summary, then, of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros. They're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Objection. Sustained.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
What percentage is 3? Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
If I told you hypothetically,
I'm going to see it side by
Yeah, and while you're over there, Popper,
Yeah.
like, lady, after that fiasco with Welcher and the multiple laptops and the smartwatch and the blah, 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 blah bullshit, you got a problem with a couple of questions? So odd. Hey, Firefly, welcome in. We are listening to the first witness of the day, Matt DeSorga. He is a event data recorder specialist and engineer with a company called Delta V, testifying for the defense, pretty much debunking everything Burgess did wrong, or showing us what he did wrong in his analysis, and proving that John's phone was locked by John after the end of the text stream event, where Karen hit him. So after he's hit and flung up into the yard, he managed to lock his phone. I'm just like, girl.
It's like, oh, wait a minute, let me lock my screen. I don't want anybody to get to my phone data.
Right?
Jesus.
Exactly. Got them
Oh, that must have been after the pirouette too, right?
Right,
Don't forget
exactly.
that.
Higgins might come out after me any second. Let me lock this damn phone up. Mm-mm. And he's basing it on the 3 point. He used the 3 point turn to line up the clocks, the 3 point turn that the authorities thought Karen did in front of the home. But upon further research of the data, no, that actually occurred over on Cedar Crest, because she passed Fairview, had to turn around and go back, and then meets up with Ricky at the little intersection, flashes his lights. Come on, girl. I'm following the timeline. Y'all's timeline ain't jiving. It takes talent to do that, right, Firefly? Immense talent. And one exploding taillight that just shattered and did all kinds of damage. Yeah, Rachel, does she understand the word anymore? I gave her a fair shake and she blew it. That's on her, not me. I tried, lady. Yeah, that's what you get. This mouth, I can only contain it for so long. It seems like the harder I try to contain it, the more it just comes out.
Following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay. Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that? What is that mechanism?
That would be the airbag control module.
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot.
What the hell with law and crimes? Shit. Ooh. Okay, hang on. I gotta pull that screen down to. What the hell's going on? I got other links we can watch it from. It's not the first time they've done that. Make sure it's them and not me. Shouldn't be me. Okay, it's back. Oh, there it goes.
The vehicle impacted with a pedestrian?
No. No.
You reviewed the raw text stream data associated with the entire.
Wait a minute, can you rewind that just a little bit? Because I think we missed.
How many text stream
something.
events or triggers were found on Miss Reed's vehicle during the course of the 8-month period prior? The
Just
vast
use your
majority,
left and right
let me
arrow
rephrase
buttons.
that. Did you come to any conclusion about, when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side?
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay. Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021?
That's fine. He's
Toyota
getting ready to
SUV
come right
570
back up to where
that's designed
it
to
started buffering.
record impact?
Yes.
What is that? What is that mechanism?
This is
That
the
would be the
ACM.
airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational.
In that the vehicle impacted with a pedestrian?
See, I don't know.
What?
That-
Oh,
it's-
wow. Okay. That's right the part that I wanted to hear.
I know.
Shit. Okay.
You reviewed the raw text stream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many text stream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
I object to the whole line.
What?
Yeah. What the hell? Okay, so
Yeah, if you use your left and right arrows, you
Yeah.
won't go back so far. You just have to
Sometimes
keep
it-
tapping it.
yeah, but so I've done it before and it took me completely out of my streams. And sometimes it does work for me, and sometimes most time it does, sometimes it won't. I don't really.
The key to that is because if you click off of the video or whatever,
Yeah.
click back in somewhere in like a blank part of the window to make sure you've got this window active again, and then do it.
Let's see. I'm gonna try to pull up the different feed though, because theirs is annoying me. Sometimes Law and Crime will do. They've done it before during trial with Lori Vallow as well.
Where
It's-
they've had a blip like that?
Yeah, oh yeah.
Oh,
Court TV's had issues. That's why I don't even use Court TVs right now. I got Boston 10 pulled up. I'm gonna try
oh.
it out. Yeah, I've had issues with That's why I don't use Court TV right now, because I've had issues while streaming.
Oh, I always watch
had
Court TV, or used to.
Yeah.
Yeah.
Yeah, as a
Um,
streamer though, I've had issues with it, so I went to the Law and Crime, and twice I think Law and Crime's done that now. So I
Let me
usually
see if I
have
can find it.
the Court TV feed saved, Law and Crime saved, and this NBC saved, because I got 3 to go to in case one fails. We've had Court TV not even have volume before, and had to leave it and go to Law and Crime, and that's when I decided just to stick with Law and Crime for a while. So I've tried them all 3, and I know which
What were
ones.
we just watching?
Law and Crime.
Oh, okay.
I always go with Law and Crime first because I've had the best luck with them, but they have messed up before. The only one that hasn't yet is the NBC feed.
Yes, he did, Firefly.
Yeah, he got objections with everything. He's got an objection with the world. Okay, they're still at sidebar. Yeah, sometimes, guys, technically, this shit's never going to be perfect, and I do the best I can with the feeds we're provided. Long Crime done messed up. We're gonna move on to somebody else then. He objects to the line of questioning, what to show that your 2 guys have bunk ass reports and maybe didn't know what they were doing when it came to adjusting time.
Oh, wait a minute. Where is this? Okay, hold on a second. I'm gonna mute you for a sec.
Yeah, I figured you wouldn't have. Hey, good morning, Joe. I figured there wouldn't be a big crowd there today. It's not for jury selection. So hopefully your morning will go smooth getting in and out of the courtroom. You shouldn't have too many problems then. Nice. Oh, goodness. Are they just big mad because we now know that John's phone? Well, we have two experts in dispute, but one says that phone locked after the text stream event occurred, and one says no, couldn't have.
Mr. Jackson, how much longer? I'm just trying to figure out.
I'm wrapping it up, Judge.
Okay.
Morning
It's
break.
not going to be long. A few more questions.
I'm not curbing you in any way. We just.
Liar, liar. Why are you asking
Respectfully, it
then?
won't be very much longer. You reviewed the text stream data,
Jeez.
otherwise known as the triggers, for the entirety of Miss Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
And last question, do any of the text stream events or do any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
Okay.
That's all I have, Your Honor. Thank you.
Okay. Jurors, we're going to take the morning recess. There's some things that we need to do with the lawyers briefly that we'll have you come back at 12.
Jury.
Morning break. Morning break.
Can I see counsel at sidebar to save us some time, please?
Save time for what? What? It's the whole point of the break. Okay, take the break and do sidebar at the same time. Gotcha. Go ahead.
How long are her morning breaks usually?
15, 20 minutes. Depends on how long this sidebar is going to be. There's no
Oh.
predicting. She doesn't have a stopwatch there, but she usually runs at least 10, 15 minutes on their morning break, or 10 to 20 minutes, depends. So, yeah, I don't ever get into too much while she's on the morning break because I don't ever know when she's going to come back.
Oh, can we back up the
Yeah.
other version?
Yeah, I gotta hang on. Let me do something. I gotta pull this actual stream up on the side because I gotta keep an eye on the live stream while I'm trying to replay the stream we missed. Or the
Okay.
glitch. Shit. It's just a lot of. Let me get this pulled up. Oops, that's the wrong one. Here we go. Let me get that back up. Okay. Now I'm Now, okay. All right, let me get to this real quick. Okay, I was trying to get it to that part, but I don't know if we're dead on it or not. So we'll just take a look at the court TV feed and replay what he was just talking about, and I'm watching the actual live feed at the same time. If I need to fast forward it, I will. I think this is the beginning of his testimony when they came back from sidebar.
And last question, do any of the tech stream events or do any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time?
Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Yeah, this is the very tail end of it, right?
This is right after they came back from the sidebar. Did I not go back far enough? Thought they had
No, I
sidebar
don't think
first.
so. Mm-mm.
Because they went to sidebar, and so I thought that he did all. Let's see.
Oh, it wasn't that far
Is there a
back.
data recorder
See,
on
I
the
don't know.
Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes,
What is that?
It's too far back.
What is that mechanism?
that would be the airbag control module.
Still too far back.
Yeah, just go
'Cause
forward a
it
little
was at
bit.
the yeah. So it was after the sidebar. I thought. So I don't know.
We record specifically.
It records a lot of operational parameters about
That's
the
what I
vehicle.
want to
What I
hear.
mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed, or the engine RPM, or the accelerations of it.
Does the TechStream data event indicate that there's and I'm talking about very specifically the TechStream data, does that indicate whether or not there's a collision in the car?
No,
Does the TechStream data event mean that if you find a TechStream data event or a trigger event, does that mean that the airbags are deployed?
no,
Does it mean that the vehicle impacted with something solid?
no,
Does it mean that the vehicle impacted with a pedestrian?
no.
You reviewed the raw TechStream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many TechStream events or triggers?
Okay, so that was what was glitched out.
Right. Mm-hmm.
Yeah. That's what and that was pretty much what I thought they were saying anyway. So yeah, at least we got that in there now.
Yeah, I just wanted to hear it because I hadn't heard anybody say, what all was covered. So
Yeah, I mean these systems are designed to cover all of it. That's the whole point of them, right?
yeah,
Especially
I know.
no, I mean I'm just in general speaking. I mean there's a lot of information these things do withhold within them, and it's just that like this guy's doing a really good job at coming in deciphering all the information versus Burgess's little bullshit experiment stuff. And only because I've watched that whole testimony. If you want to eat some popcorn, you do need to watch Burgess's testimony again. Whether it was quite a show.
Yeah, it looks like Court TV's chat. They have a poll. 80% are on this guy's side. They're believing this expert over the
Yeah,
others.
their chats are usually fired up. I don't usually watch them while I'm streaming, but if I'm waiting on the thing to start and I'm watching their feed, I
Mm-hmm.
laugh at the comment section, but while I'm streaming, I don't. I know a lot of you guys are bouncing around between me and these bigger
I
platforms,
only saw it
but
because I
yeah,
went looking for the
yeah,
video.
I don't know. I have while I'm streaming, I can't keep an eye on what they're doing over there. But comments are so funny sometimes. It's just and the troll accounts that come in with their crazy names, Welcher's emotional laptop support laptop. I mean, there was just all kinds of really funny names. Jen McCabe's this and that. I mean, I was laughing at just the random things people put in these chats is crazy.
Mm-hmm.
It's quite comical. I'll sit out back sometimes with a cup of coffee and just laugh. Like, you people are funny. I love to laugh. Like, they are still on break. Got the OnlyFans is spinning around and around. Uh-oh.
So I missed the rest of it though. So basically, he just said no accidents ever recorded on her ACM.
Right. Out of the 19 trigger events recorded, none of them were triggered by an accident
Right, and
or
that.
hitting
Yeah.
or hitting anything.
Mm-hmm.
No airbags ever deployed. No,
Mm-hmm.
nothing. Yeah, some exploding taillight pieces.
Did he say anything else?
No,
That was it.
he was basically there to dispute Burgess's findings.
Yeah, I got that. I mean, just the last couple of minutes that I missed.
No, not no.
Oh,
Mm-mm.
okay.
The key takeaways, all the fluff in between, the describing stuff, I'm not writing down, but the key points that goes against previous testimonies by other people, that's what I'm writing down. And for me
Yeah,
to
I just
remember,
muted the last few minutes. That's why I missed what
oh,
he
I
said. Yeah,
if you
because I was listening to the stream that I was trying to find.
no, he didn't say anything else.
Okay.
I gotta go check on the grandchild for a moment. He slept in this morning for the first time in a bit. What are they doing? Oh, they they
Mm-hmm.
were throwing things up on their screen, and I'm like, "What are they doing?" I get it. Okay. They tripped me out for a moment. Okay. This is the court TV feed we're looking at now. Same exact feed, just the names are hilarious, butterflies. Like, people have some really good imaginations out there and can bust these accounts out on the fly. All right, let me go freshen up my coffee and check on the grandbaby for 1 minute. I'll be right back.
Mm-hmm. I just checked the Idaho cases of interest site. There are a couple of new things, and they have to do with jury instruction. Motion to seal state's proposed supplemental jury instruction, and then an order sealing state's proposed supplemental jury instruction. So I personally think Hippler is just, moving forward, and he's probably not going to grant any kind of a continuance. They've got phase two mitigation witness list, trying to seal that. Hmm. Oh, you hope he doesn't grant a continuance? I really don't think so. Because, I mean, think about it this, too. Look at the money that they have spent, like that it's cost the state just trying to, handle that whole case so far. Because, I mean, at the very beginning, they gave them, like, what, $1 million, right? It's been 2.5 years. Can you imagine how much they've spent? Actually, let me see if I can find out. Does anybody in chat know? Trial budget gets bigger. That was in August 2024.
What is
Oh,
it?
oh, I was wondering how much it's costing.
Oh, yeah.
Idaho for Koberger. There's a couple of new documents, but it's just
Yeah.
jury instructions,
Yeah.
order to seal, and
All of these cases rack up to the millions these days.
Butterfly was saying that she hopes it doesn't get a continuance. And I was like, I don't think so, especially not with the money that they've been spending.
There's going to be other remedies the judge can take as far as all that goes without having to continue the trial.
Mm-hmm.
If he decides a remedy needs to be considered, which there might be, um, but continuance isn't one of those remedies, I don't think.
Oh, I actually feel better. I was coughing a little bit, but well, a lot between in that last testimony and everything. So yeah, that's probably why I sound worse. I sounded better, I think, earlier
You
when we
did.
started this. Yeah, I
Yeah.
had a bad coughing fit, so I need
Well,
to get up and get some tea.
oh, goodness.
No, I don't see an amount, like a
Yeah,
total.
she sounded pretty good earlier this morning, Firefly. Now she's sounding a little rough. No, you do sound better than you did yesterday, though, compared to that.
What?
You tell you feeling
Sorry, not
what?
talking about that.
What? What'd you say?
Breaking news: Supreme Court allows Trump to begin removing 500,000 immigrants.
Oh boy. We is okay.
Cuba, Haiti, Nicaragua, and Venezuela.
Mm. I couldn't tell you what's going on in politics for the past 2 years. Turned a blind eye to all their bullshit. I sure did. I turned it all off in one day. Just done. Done with all yous. I could care less.
Wow.
I know. I don't even. I'm scared to look sometimes as to what's going on. I don't even know. I'm over it.
Shit. Okay. Let's see. Where was I?
Hey,
Looking for something
you
else.
pardon the Grizzlies, whatever their name is.
Chrisley's. Yeah.
They're having a press conference sometime today.
Mm-hmm.
They didn't want to
Yeah.
be
Their
seen
show was
yet.
like Chrisley Knows Best or something like that.
Yeah, my son and daughter-in-law used to watch it all the time. My son's like a huge fan, and he was held in prison here in our town. I used to tease my son about going down there and visiting him. I was like,
Mm-hmm.
"Don't you be sending no money to that man's books now.
Mm-hmm.
Get him some snacks." They didn't want to be seen in public yet. They got to go home and doll themselves up.
Mm-hmm.
Mhm. But hey, let freedom ring.
Oh, it says it already exceeds 3.6 million. That's in the Moscow Pullman Daily News
Yeah,
from April of last year. So,
it was getting close to that before then. Remember, it was well over 2 million before that update. So
yeah,
it's
this is April 18th, 2024, 3.6 million.
yeah. I think Delphi was just a little over two for the state of Indiana. I don't know how much this is costing the Commonwealth. That's par for the course anymore.
Oh, these fools? Yeah, but
Three
yeah.
years, 3 years to go to trial, and at least $3 million, and at least 65 terabytes of data to move through. Welcome to trials of the future. They better get it together a little bit. That's all I'm saying. They know what's coming. We ain't stupid. We see it.
Oh, I see something here too about family fundraising. That reminds me. I saw, what was it? Something for Kara,
Oh yeah,
GoFundMe.
I
Hmm.
posted it into the Discord.
Yeah, I was
I
like,
saw it actually. The news broke out
mm-hmm.
a few days ago. I just haven't reported on it. I just I haven't. I don't know why. Um, no particular reason why, but yes, there is a GoFundMe set up now for Kara Northington to make it to the trial. I don't normally share out GoFundMe links and all that stuff, but it's out there. One of her
Mhm.
friends, I think, started it for
Mhm.
her to be able to go to Boise and stay during the whole trial, which she has the right to go as well as all the other parents.
I just hope she manages it for her, though.
Yeah, well, par for the course. I'm gonna let Kara do Kara. She's a grown ass woman. That was her child, and she wasn't there for the most part. I know that for a fact because we heard her say it in her own words in an interview done right
Mhm.
here on the YouTube streets. So I hope that somebody's holding the lady's hand. She's probably gonna need it. But by all
Um.
means, go on down there. I don't know how much they've collected or anything like that yet. I didn't look into all that mess.
Yeah, I was looking for the
I
page. I was
haven't.
just gonna go
I
check.
haven't. I don't even think she's posted on Facebook in a while either. But honestly, I haven't went and checked. I don't really think about those parents unless they pop up on my news or something, or I've seen some random shit somebody else posted. Half the time, it's not even worth talking about, but sometimes it is. She has.
So,
She's been kind of quiet lately, though.
I thought the woman said in her interview or whatever that it was 50,000 because it says the goal is 26,000.
It was 50,000 is what I heard also on the report, but who knows?
Yeah, it's. I'm
I
looking at it now and it says
I know that if
26
I was
and.
a family member, it's fixing to be a real big burden on me,
Mhm.
regardless of how much money I have in the bank or how good my job is. Going out of town for 3 solid months is about to be a big ass burden.
Mhm.
So however they need to get there, get them there. And it's not the first. We had the same thing happen in Delphi with Libby's mom. She needed to be able to get to trial and stay comfortably. There was a fundraising effort for her to get there. This is going to be normal for family members going forward, especially when trials are moved to different counties and all the things that are happening. They'll keep
Yeah,
that.
Rachel, I don't have a problem with her going or whatever in the GoFundMe or whatever. I just hadn't looked at it or
Yeah,
whatever.
there's
So,
other.
yeah, I hope she does go.
Yeah, she needs to go, but there's other circumstances, Rachel, that cause worry with Kara. And
Mhm.
that's only because Kara put all that out there herself. We didn't go digging it up on Kara. Kara brought it to the YouTube streets. If you know, you know. So yeah, either way, you know, they're gonna do them. They're all gonna be there, hopefully. No, we don't know if he's gonna delay the trial, Rachel, but logically speaking, and if you look at what other defense attorneys are also weighing in different things, I don't know if he's going to continue that trial. There's other remedies that he can take action on to provide what she's asking for without delaying the trial. And when I say remedy, that's the legal term for it, for the leak and the other things that she cited in her continuance motion. And the other remedies could possibly be remove the death penalty or keep out some of that evidence that Dateline presented. Yeah, Kara's done. YouTube streets got into that lady's head, and she made it very well known. Some of the people she was watching to gain information from were steering her down the wrong road, unfortunately. Paying attention to what a clown says and running with it. Have to question intelligence levels at some point. The thing about Kara Northington is Kara carries a lot of guilt because she wasn't there when she could have been, and that worries me for her, right? Because that guilt, when you lose a child, the guilt alone if he did nothing wrong, that still what if, what could I have done differently is always going to be there. But if you are a parent with the types of regrets that she has, it's triple fold at that point. So there's a lot of moving parts to that lady. And I hope she's receiving the help and she needs. And she was exploited on the YouTube streets. That's about all I got left to say about Karen Northington. I'll say it again. She was exploited on the YouTube streets. We don't even know if the Chapins are going to be there for the entire trial. I know there'll be days that if Stacy does decide to go, because she is contemplating going ahead and going, because she said in the beginning she wasn't going to go. There's things that are going to be said she doesn't want to hear or doesn't need to relive because she already knows. She's already you got your death report. We can all speculate all we want to, but I guarantee it from experience, those parents have all their children's death related information, all the autopsies, all the reports from the coroners. That is their right and they have it. And once you put a birth certificate in the same envelope with a death certificate, you know what happened to your child. And you don't need the court to tell you because you already know. So Stacy has now decided that maybe she does want to go because she's had time to sit with all the information and she knows that someone needs to go represent her son. But I do know there will be days she doesn't go into the court, especially when they start showing certain photos and talking descriptors, right? Oh, they did, Rach. They did. Called it helping. It was called clickbait. I guess those of us who have followed the Idaho 4 case since before Koberger was arrested, we've seen a lot with this case that I think people, in fact, something came across my feed yesterday that was 2 years old. And I thought, oh man, I haven't seen that in a long time. So I watched it and it just took me right back to all the bullshit of Idaho 4 that started with this case. And it was like, holy cow. Let me just say, publicly buzzed, I freaking love you. You are so honest and you are so accurate. And it was great. It was one of his old streams. And just there was a lot there. And I was like, man, that we've really been through it with this case, right? Like some of this stuff in the Reed case is like the Delphi was like, whatever. Idaho's like, hold my beer. We got stories to tell. With Delphi and Reed, there's one alternate story to tell. With Idaho, there was 50 alternate stories to tell. And apparently Ann's got one too. Ann Taylor's going to throw hers into the ring. That one is making me curious. That one's the only one that matters. I don't think the judge will take too much longer, though, to make his decision because they needed it. And there's still only 2 more hearings scheduled. 2 more hearings scheduled before the trial is slated to start. Yes, Sajoy. Yes. Most definitely. Welcome in, by the way. Yeah, Rachel. Rachel was one of those ones that received that vandal alert. I wonder, what time did that alert come in? Because I want to see if it jives up with what WSU mom Kim's out there slinging. Damn, Rachel, send me that. Send me the timestamp on that vandal alert, please, ma'am. Just for shits and giggles. They're on break this morning. They're on their morning break. Yeah, the witness testifying is Matt DeSorga. He is the engineer and accident reconstructionist, EDR specialist, the event data recorder specialist. He's up here disputing Burgess's findings. Right? He's explaining the clock drifting situation and how Burgess's calculations were allegedly wrong. I find this guy way more credible than Burgess was. Far more credible. I actually found him far more credible when I watched that video yesterday evening that I saw that he did on YouTube. I was like, because I was researching him and I found that video and I watched it. I was like, oh, this guy's going to be a beautiful witness. He's going to be able to get up there and explain his business in layman terms. And he's going to absolutely be able to dispute Burgess's findings. And that's what he's done so far. And it's weird because Bev keeps wanting the defense to, rephrase the question. But we had to sit there and watch Welcher do all kind of nonsense on the stand, including boss around everybody, the judge and the defense attorney. And she allowed it. She likes to be bossed around by the men on the witness stand. Was around noon. You didn't hear any of them crazy stories that Kim was out there telling, Rachel? It was way more than that, Firefly, right? It wasn't just the fact that he couldn't give a straight answer. He couldn't even get his education right. Oh, we might know why now. Why it's taken 17 years. No shade on anybody going to school, living life, and doing you and getting that degree done. He's in a 17-year pursuit. Life really got in the way for him. Did he jump the gun when he got excited when he found that SD card that nobody else found? He's like, well, damn, there's the answer right there. Oh, wait, I damaged it when I removed it. Oops. And the new witness says that John's phone locked at 12:32:09 after the event text stream ended at 12:31:43. Now, I know you heard her stories, Rachel, but were you hearing the stories? Because if Kim knows all the stories, that means everybody was talking, right? So your kids didn't hear all the same crazy stories. That's where I'm going with that. Y'all weren't hearing the same bizarre, crazy shit she was hearing. You know how them kids all talk. According to Kim, all the kids knew, that this was a ruse. This was not what really happened. They all know. They're just scared to talk to their moms and tell them. Fake credentials from Timu. He hoped. He's like, I'm going to hope for the best. They also have another witness lined up on their defense witness list. She is the phone data digital forensic examiner, Maggie Gaffney. I don't know what order they'll call her, though, because I was reviewing their updated list last night. And I look specifically for the experts in these fields, right? Because I know they're important to contradict what the other experts have told us. So I'm interested to see what she has to say as well. It's going to be interesting to see how the prosecution handles this witness on rebuttal. He may not be as ass kissy as Welcher was. Ooh, I hope I have a pretty weekend. It's nice today and the birds are singing. I like a nice weekend. Yeah. Yep. Made up crap. But according to her, every kid in town knows it. Yep. Lady, go sit down, right? Right, Rachel? Tell her to go sit her ass down with Lori Vallow in the corner. I know if I was a particular mother of a particular victim in that case, that lady would have got a knock on her front door a long time ago. And when she opened it, I would have said, I'm a mom too, bitch. You guys are a trip. I'm starting to get a little hungry. What are y'all eating today? Yeah, you know it, Butterfly. You read my mind. We are the same. I've already concluded that. I think we're the same. Yep, throat punch. I'm a mom, bitch. Bam. I'm probably going to get in trouble with the YouTubes, but I don't care. It wasn't a direct threat, it was a scenario situation, a possibility. Oh, known as the nut job. Ann Taylor did stand up in court and say, well, Your Honor, some witnesses have spoke to the media too much. I'm like, witnesses have spoke to the media too much? There's only one that I can think of. WSU Mom Kim. And do you count social media as the media, ma'am? Because she's the only potential witness out here talking to anybody. Oh, I haven't. Wait, I'm gonna be mad if what you got some brisket going. Firefly up here with the Chipotle. I haven't had Chipotle in a while. That's my kid's favorite place to eat. I had to get him like gift cards and stuff. So when he's off at school, there's like one right next to his school. He was like eating there all the time. I'm thinking egg salad. I'm not going too bold today. Not too fancy. Not like Dolphin's breakfasts that she orders. Go ahead and tell me, Butterfly. Get it over with. Rip off the Band-Aid. Oh man, girl, them burnt ends are the freaking best. The best. One of my kids is like, that's so gross. I'm like, dude, that is the best part. I got myself a steak last night and I was a little disappointed. Yeah, Dolphin, her bougie ass breakfast. Every time. They sound so good. I love a good charred piece of meat. Does that sound weird, but true? I like my stuff done on top of that. Even my steak. I can't really do the medium well, the rare and all that. I gotta have it cooked. My son says I cook stuff a little too long. I'm like, I don't care when it comes to my meat. That shit better be done. Don't sneak some half cooked meat up in on me. I'm ready for a good slab of ribs. I think I need to get me some from the grocery store and just throw down. Sit me down in front of a plate of barbecue ribs and it's going to be all over with. Well, they've had some minutes on their break now. Maybe they should be coming back soon. Oh, Rachel, it is worth it. So worth it. I need a new grill. I need to get a smoker. That's one thing I don't have as a smoker, and I've always wanted to get one and just, try it out and do the things. I bet they were. If y'all are like me, they were gone, right? Make a lot. Not everybody in my household is as big on those as I am, but I love me some ribs. And my favorite store sold their shit to Aldi, and they were so good about getting out there all summer with their big smokers and cooking up the ribs right before your eyes. And I could buy me a slab for like $12, go home and get in my bed and just be happy. But no, they're not doing that anymore. I don't think Aldi will make ribs and sell them on the sidewalk. You got to pay them for a damn buggy. Joe says when he tailgates, he likes to make pork belly burnt ends. They disappear fast. You know it. We need to put a pig in the ground, y'all, and roast that bitch on up. Have y'all ever done that? That's the thing here in the South. Dig a big old hole and throw him in. I hear tell that Joe Schmo's a good cook. I like a man that can cook and make me laugh. Joe? I'm just gotta have separate houses and all the things. Hell, at different states, I don't care, but you gotta be here to cook my supper. Cook my supper, then go home. Make me laugh first, and then you can go. Yeah, those pellet grills, I've heard. I don't know if I don't know, right? If I want that or something different, but it is time for a new one. My dad makes sausage out of deer sausage, and that is the only kind of deer I will eat is the deer sausage. Y'all can make your own. Oops. Well, at least you remembered your granola bar. Butterfly, we are not reminding Joe to take his snacks, but look, he remembered on his own. Um, we had to get on him and other trials for not doing that. But he cut his granola bar. We were all wishing we were sitting around the backyard with you around the smoker, dude. Let's get it on. Good food. Joe, what? So Joe's in Arizona. It's 11 Central. What are you? 9 a.m. your time, Joe. You should be getting into the courtroom soon, right? Yeah. I don't know, Firefly. Oh gosh. So that's probably, another reason why I'm single. The dude's not going to take too kindly to me saying you need your own house and go home at the end of the day. He's going to be like, "What? You heard me. I'll see you tomorrow, maybe." Depends on my mood, dude. I'll call you when I'm bored. Oh. I'm into long distance relationships. They're easier. I'm that girl. If I got to work to make it work, baby, it ain't going to ever work. So we're out. I'm not working on anything. Not at this stage in life. You work on you before you get to me. How about that? Because I'm not here to fix you either. You grown ass should have had some therapy by now. So, Joe, it's 9 a.m. and you think it starts at 10. Boy, you did get there early. Now you see that maybe they'll get that jury seated today and you won't have to go through it Monday. I have to stop and think. Is today Friday, Saturday, Sunday? What day is it? Guys, I got to stop and go to the restroom real quick. I'll be right back.
Back in session, you may be seated.
All right, Mr. Brennan. And Mr. DeSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here, so if you just speak directly into the microphone, that would be great.
Not a problem, Your Honor.
Thank you.
May I proceed?
Please.
Good morning, sir.
Good morning, sir.
Sir, are you trying to offer an opinion suggesting that Miss Reed's Lexus never hit John O'Keefe on January 29, 2022?
Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Miss Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Miss Reed's Lexus never got into a collision before January 29, 2022, or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, were you?
I think you threw a double negative in there. Can you just clarify what you
can.
meant? Yeah.
You are not suggesting to this jury that Miss Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Text stream data can be triggered by a number of different things other than a collision, isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right. Right. So there's other things that will trigger text stream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
Holy shit.
if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of depressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a sideswipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data in the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the case.
You're saying it would meet that?
Would not.
Would not. Okay. And a sideswipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event. Would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture report's referenced.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No,
You have no idea, right?
I don't.
Okay. I want to just ask you some questions about your background and then leading into this case, if I could. You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month, correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction, it was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus, as part of your specialty, on EDRs, don't you?
That's correct.
Event data recorders?
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it, but oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Oh, yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones. Are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher, yes?
Yes.
And Mr. Shannon Burgess?
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this case?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case.
You what?
Mr. Jackson,
Right, okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about? You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Okay. Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
But they had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So it's sustained.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's
Yeah.
no reason for you to hold on to it for a couple extra days.
No, I think it was the 25th.
Do you know when it was provided to the Commonwealth, that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information, new information, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked you?
My clients, Mr. Jackson,
He said, please add this on the 25th.
we had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
Okay. When you first got involved in this case, it was last fall,
Correct.
and at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
And there was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules and try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining those oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So, can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Reed's Lexus materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained.
It's strict.
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips?
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits, and Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip-off, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mr. Burgess' proposed protocol labeled reattempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it for actually, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think, in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on and ignition off information
Yes.
in an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. Pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry, so can you restate it, the whole question?
I'll ask it again.
Yeah.
You said you have some experiences in accident reconstructions.
Yes.
Don't you want all the data available? The more data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, as a data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and the time that you can match with the text stream data, correct?
Yes, it does.
As you know, text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead, like
That's
a stopwatch.
correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there, if someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustained. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips, and it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas, and then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
Objection. Sustained. You can ask it to.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there, there could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr. Burgess work, as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
Oh,
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Okay. Did you do any study yourself?
No.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on the
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
I understand your point.
Yeah.
If you see, as an analyst, a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. DeSorga's new PowerPoint, 52525. You've made a modification to your PowerPoint.
Yes.
You've made an amendment to your PowerPoint.
Yes.
So there was something that happened, you received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible, so I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
Objection.
I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say, generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Okay. We can turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did not.
reports. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation, so I'm taking them at face value, but as being correct.
Well, it's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the three-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Turn to the next page, please. You point out 2 times for the jury, the Lexus event 1162-2 ends 1231-43, right?
Yes.
And that's based on the clock in the infotainment system.
That time is based on 2 things, the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of 2 values.
which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 123209 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 123209.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are two different devices, two different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so, in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, the way I'm not the only instructor, collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right, like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger knot.
Absolutely, and that's why I didn't change the convention here. I used their convention,
So you're
apertures.
not suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No,
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No,
So you're not offering criticism on that, so just so I understand.
not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis, so I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were
A little
suggesting
different.
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds to the time of the trigger because you're starting at the end from both devices.
Objection, Your Honor.
I'm going to allow it if you can answer it in that form.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, they were basing it off the end of the event, the end, not the trigger, the end, comparing it comparatively to the end of a different device. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
you see 12:32:09 minus 12:31:43, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly, before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report? Isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in that.
Did you see, when you reviewed reports, that Dr. Welcher uses this exact number, plus 26 seconds, in his report?
I got the number from the PowerPoint.
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just
And-
copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough. Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with. Widen that a little for me. So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Objection.
I want to see you at sidebar.
I knew that was coming here soon. And it's almost lunchtime as well, so I'll be surprised if they don't go to lunch after this is over. I'm totally checked out on his rebuttal bullshit here because, yeah. Because I am. The judge has irritated me. Oh goodness, Dolphin. I hope, did you take your medicine? Maybe it'll kick in soon and get that cough under control. So annoying, isn't it? Right, Sajoy? He can testify without 2 laptops and a smartwatch and a smart mouth. It's so crazy how they allowed that witness, Welcher, to be such a smartass on the witness stand to everybody in the room. And Brennan's going to be up here and be just as smartassy, but a little more subtle about it. And the judge is like, cool. But the defense says, rephrase the question, sir. Lady, now you're irritating us. And now the jury is really going to notice your bias. Before they were probably giving you whatever. But now it's going to really show. That will impact the jurors. They're going to wonder why. Remember all those times you allowed certain witnesses to be a certain way, and you allowed the prosecution to get away with certain things seemingly, and you always seem to do, they're paying attention. Because after a while, you can't help but pay attention. And on the simplest things, she's getting them. Just ask it differently. Well, let me just be real blunt then. Quit sidestepping with all this jargon. They wouldn't like my blunt ass up in that courtroom too much. I'd probably be in trouble all the time. I would get told to ask it differently over and over and over. I'd be like, how about this, judge? You write down the darn question that I'm allowed to ask. And can we put that on the record that you did that? Crazy. Sorry, I was kind of shopping at the same time. I had some things I needed to get from the Amazon, so I was doing that while they were going on and on there. Hank comes off like a condescending ass. If I was a juror, I would find it rude. And yeah, exactly. That's what I'm saying. They're up there objecting every time they want the defense to ask it differently, and they're killing them with the defense is trying to kill them with kindness over here without becoming too snarky because they know the jury's going to notice that too, right? They're not stupid. They understand the jury's going to have perceptions, and so let them look like the jackasses here. Let's let them do that. And hopefully that sits with the jury, right? We got a little bit of movement. She's going to come and say time for lunch. She's not wrong. It almost is. We'd be in jail for contempt. We need a permanent a bail fund set up permanently because one of us will be thrown in there. We're all like on the defense team. Like one of those moves where you bust over the thing and get to the judge. That's why I couldn't trust myself going to Lori Vallow's trial because I don't know if I can trust myself being in the same room with that woman. Like literally, I don't know if I could. I'd be bursting out laughing at certain times. I'd be going, oh my God, at certain times. I would be that reactive person and I would get tossed right up out of there. I'd want to nail her one good time for everybody. Close that portal once and for all. Bye. Lights out. Rachel, you bouncing around? Who's reporting that? Who's reporting that? Are they reporting in real time from the courtroom? So you better watch out putting her. If a juror put their head in their hands, the judge is going to reprimand her. She's not even allowed to make a face. How dare you put your face palm yourself? Yeah, exactly. Love it when you guys chime in. Girl, my face cannot lie.
So jurors, we're going to release you for the luncheon break. I took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you back here in an hour.
1 hour. Okay, the clock is running. It's 11:54. Was he in court today? Is he reporting live? Cool. I haven't trolled. Well, I haven't trolled. Actually, like in a week and a half while we're live, I haven't trolled Twitter at all. I kind of like needed to stay away from it while I was streaming it. I wonder how much more the prosecution thinks they can pick out of this guy to make Burgess look better and smart. You know, he really emphasized that, like I did, Burgess was the one who found that SD card, the SD card nobody could find. That explained where that missing block of data was located. And it happened to be located in the EDR, not the one in the console like they all thought. And then when it was all soldered and all that stuff being done to get that little thing out of there, he sure enough damaged it. He testified to all of that. And I knew they were going to bring that up at some point because there's information about this guy in that video I watched about getting information off those damaged EDRs. 1 second, guys. My grandson needs something. I'll be right back. Okay. He was letting me know he took care of his breakfast, little self sufficient dude. I heard him in there rummaging around, but I didn't know what he was doing yet. He hasn't been up long. He took advantage of his first full day off of school and he's like, I'm sleeping. They were out late last night, though. They went to a graduation and then to dinner, so he was exhausted. All right, guys. So let me pull up something here. We'll take some time to review some stuff we haven't. Um, yeah, Oh, so back to that, right, Rachel? I'm sorry, I got sidetracked with the grandbaby. Because I was like, out of all those damn experts that we've heard testify, well, there hadn't been that many on the EDR stuff, but data dudes kind of people. Burgess come in hot, that smartest guy in the room. I found this missing SD card and blah, blah, blah. And now we're hearing that, this guy, DeSorga, knew about him finding that SD card and all the things. And we just heard that whole testimony. So I'm able to put those two together because I remember what Burgess testified to. And they just have very different conclusions on how to align those clocks, right? And then the prosecution's now trying to discredit DeSorga because he doesn't have cell phone data background. I don't think it's necessarily needed because he's not analyzing cell phone data. He's looking at the clock system stuff, right? And so Joy says Burgess lost me when he confused. Yeah, the bits and the bytes. He was all confused about his bits and his bytes, wasn't he? He was confused about a lot of things, and and the way that Brennan went after this particular witness about your education, we're like dumbfounded by that when we saw that Burgess display happening before our eyes in real time about his fiasco with his degrees, and the lack of. But here this guy is with all kinds of degrees and training, and you're just like, and he got real smart with him. Said things that he knew were going to be stricken from the record. But he calls the defense out on stuff like that. You got to watch these slick ass attorneys. They think they're being slick when they're not, right? And it'll come from both sides during different trials we cover. We'll see that snark come out on both damn sides. It's just crazy when it happens, especially if it seems like one side's allowed to get away with it when another isn't, right? We know that's not fair. That's not fair in the real world. When you start acting like little children screaming, that's not fair. You could stand up in court instead of saying, I object, scream, it's not fair. Yeah, Burgess was out to, make a name for himself, maybe. I really need to get some good information on my CV and my whatever, my background. You know what I mean? I'm still working on that degree. This might help. We're like, okay. Okay, so this I saved it from, I think it was yesterday. Let me think. Is this the right thing? Hold on. Yeah, it's a microdots. Okay, it's a microdots thing, and this is because this to me is some of the most important information. So we already got. Okay, so if the stream event started at 12:31:38, it ends 12:31:43. It ends. John's phone logs at 12:32. The reason I'm going like that at the timeline because we got Nagel coming in and texting Julie at 12:23. How long does it take Julie to get out to the car? They spoke about 5 minutes. Nobody still sees John. Then we got phone movements happening with John's phone. The inclines and all that has to be added into that timeline. So this is something that Microdots did, and it was based on the movements of the Karen's vehicle, the going forward, the back, the whole time events sequence there with the going up forward and backwards. And like I was saying, how far up do they want us to believe she went past that flagpole to back up the 53 feet to hit John? Because where that impact happened is really important to me because I know where the body landed. So if you're telling me she backed up further than that and hit the guy, you're not going to tell me he flung into outer space and back down into the flagpole area. Not happening. So I just wanted to review this with you guys because it's a good visual on what they were talking about. Pounding the podium. Right. He's up there going Tarzan style on them. He's like, I'm going to go all Tarzan on you guys. All right, let me get me and Dolphin out of the way. I know y'all just will miss us, but there we go. We'll be all right. Okay. Here we go. Let's watch this microdots piece.
One of these little hash marks, a different color, represents 10 feet. The red lines show the extent of motion. Remember what I said, it initially pulled forward, then backed up, past its initial spot, and then went backwards further distance. So what this shows is where we simulated this in a program called HVE. So that's the vehicle, the Lexus pulling forward. It's still going approximately 23 miles an hour when that ends.
According to Commonwealth expert Judd Welcher, Karen Reed's Lexus was idling in position a short distance ahead of John O'Keefe, somewhere just beyond the flagpole. We'll refer to this as position 0. He claims she drove forward 34 feet and stopped at position 1. Position 1 is even farther from the supposed point of impact than previously believed, and that matters. More distance means more time for John to react. They'd have you believe he was just standing still, willingly making himself a perfect target, so Karen could attempt a 1 in a million shot and actually make it. Fairview Road is typically quiet, with little traffic and minimal ambient noise. In those conditions, the sound of an approaching vehicle speeding towards you wouldn't just be audible, it would be alarming. Welcher asserts that Karen pressed her foot down on the gas pedal, applying 75% of its full range, and accelerated toward John, reaching a speed of nearly 24 miles per hour, traveling a distance of well over 87 feet, turning the street into a slippery racing strip, striking his bent arm, causing the mismatched wounds, and projecting his body through the air, or in some other way, to its ultimate resting place just below the flagpole. The Commonwealth mostly glazed over this aspect of the collision, likely because it's the most unbelievable part of their theory. They provided no scientific evidence explaining how a taillight could produce the specific pattern of abrasions on John's right arm, how he sustained no broken bones or significant bruising, or how he managed to lock his phone after being incapacitated under this scenario. Another problem is that Ryan Nagel drove by just moments before and didn't see John inside or outside the SUV.
I was making sure my sister got in the house okay.
Specifically testifying that Karen was alone.
But you did look inside that SUV,
As I passed by, yes.
and you saw one person,
That's all I saw at the time, yes.
female with long hair. Is that
Correct.
right?
After the SUV travels 87 feet, the trigger event data ends, but the vehicle is still accelerating, with its last recorded speed being its highest.
It's still moving. It's still moving about 23 miles an hour, and you're still at 74% throttle and 3,300 revolutions per minute on the tachometer, RPM gauge.
It's not just still moving, it's still speeding up, and Karen is applying zero pressure to the brake, which is a major problem for one big reason.
Exactly where was your Jeep in front of that house?
By the mailbox.
Okay. Can we have, with the court's permission, Exhibit 66?
Okay.
This is a graphic representation of 34 Fairview, not a photograph. Just to orient you, do you see what's depicted in Exhibit 66?
Yes,
Do you recognize it?
I do.
Do you see the mailbox, which is about right there?
Yes.
Okay, where was your Jeep in relation to that mailbox?
So the back end of the Jeep, the rear, would have been about around equal with the mailbox, and I was not blocking the driveway.
Okay, so you would have been about there, correct? If the right edge of that highlight is the mailbox being right there, you would have been about right there on the street, correct?
Well, that would have been the front of the Jeep. Where your laser pointer is, it would be the front,
Okay, so the front of the Jeep was facing the flagpole,
towards Chapman Street, correct.
and the rear of the Jeep was basically even with the mailbox strut or stanchion.
It was definitely past the driveway, yes.
How could the Lexus have been accelerating in reverse at the speed of 23.9 miles per hour when it would have collided with the Jeep, causing a violent crash that would almost certainly have severely damaged both vehicles?
So when you were talking about the vehicles that you saw in front and with some painstaking detail, talking about the black SUV and Ryan Nagel's truck, you just left out the Jeep because nobody asked you about it.
This is what happens when you build a theory on bad data and invented narratives. Lies stacked on lies eventually collapse under their own contradictions. It's the inevitable unraveling of a story stitched together with fiction and falsified evidence.
You had no reason to believe they weren't okay. A man was dead or dying on their lawn and your sister's not answering the phone. You didn't think there was some reason to believe they could have been in peril? You knew better. You knew she wasn't in peril. You knew that Brian Albert wasn't in peril. You knew what really happened.
It's a good visual, right? I like that. Too bad they can't use that in court. Be like, here, jury, here's what they claim happened. Does this make sense? And don't forget, this Jeep is here one minute and not the next. And that's the thing. I agree. They need to call Higgins because it's his Jeep, and either it's in the way or it's not. And you've got two different witnesses who just testified. One seen the Jeep and one did not. So was it there or was it not? The only one that can clarify that a little maybe would be the owner of the Jeep. And the Jeep is a big issue if you want me to believe this girl backed up all that like we just saw without hitting this Jeep that was in the way. Nagel says that Jeep was not there when he was behind Karen. And if you go by what the prosecution's timeline is, they're wanting to place John in the SUV with Karen while he was behind her, Nagel and Ricky. And that when they passed her and just saw Karen, they wouldn't have seen John because it was too dark in the vehicle. Well, the defense has pointed out, no, that's not accurate. But that's what the prosecution wants us to believe. And then once Ricky and Nagel and Heather passed, then John gets out. Because remember, Karen pulls up. Nagel sees it. She pulls up again, closer to the flagpole. Then they drive away after talking to Julie. Then Karen accelerates backwards and hits John, who's just standing there going, okay, girl, leave mad. And he hears her coming and doesn't get out of the way. Yeah, this is not making sense. Microdots is good at what they do. Yeah, they want justice for John. Their visuals are great. You know, I appreciate any time there's and they're going by what is testified to, right? And a lot, even like with their waterfall videos and their narrative and their commentary is great, but we take it all with a grain of salt, of course, but it's like you get the feel for it. So I'm appreciating what they're doing visually. I like to learn with, visual things to help us get there, right? And it's just to me that's a really big problem, having that Jeep there versus it not being there. And I think prior testimony puts the Jeep there between 12:31. There's nobody's been able to pinpoint a real time on that Jeep, except Higgins shows up at the Canton Police Department to move cars around and walk through the building. and jump on his phone and all the things he was doing over there. It's not that far from the home, so that you calculate how long it took him to get to the police department. And you might could come up with a decent time of what time that Jeep actually left that house. And remember, he left because they didn't have whiskey, only the beer. So Higgins has got a story to tell, and I'm here to hear it. I'm here for it, sir. I want to hear it out of your own mouth. I do, I do, I do. Okay, let me see. Okay, so as Dolphin had mentioned earlier, there were a couple of new things in the Idaho case that came down, but they're nothing jaw dropping. It was order sealing the state's proposed supplemental jury instructions, order sealing the defendant's amended phase 2 mitigation witness list.
Mm-hmm.
Yeah, motion to seal the mitigation list. Yeah, nothing new or exciting that we can jump into. I'm not reading a motion to seal a motion or to seal a document. You know what I mean? It don't even tell you nothing. But we are still waiting on the ruling, of course, for the continuance or whatever the judge decides to do there. I'm curious about the investigation into the leak. That just intrigues me. Who the hell thought that was a good idea?
Did he say anything about how long it might take him to decide?
He really didn't.
Mm-hmm.
Ann filed the big continuance motion. He did say if necessary he would appoint, a special prosecutor. And we knew right then, this minute that day was over, that investigation was started, right? And then he immediately came out with the preservation orders. So there's no doubt in my mind there's a heavy investigation going on into that. They're not going to wait around on that one. Um, what kind of person decides I'll leak this really valuable information that is critical, maybe or maybe not critical. It depends on the weight of that particular evidence. But what kind of personality does that?
I mean, people been leaking for a while, though. I mean, what
Yeah,
if
but to this
Dateline just
level,
sat on it? Mm-hmm.
well, this level, if you go, well, there's something I haven't had. You were gone on vacation, so there's
Mm-hmm.
something that I haven't had a chance to talk to you about yet. Um, yeah, they've sat on information for a while, and rumor has it there's more to come in July from somebody who seems to know an awful lot about this leak situation and how it may have occurred and when information was going out and all this crazy stuff.
Mm-hmm.
Okay. Yeah, I'm just curious as to what officer. I get Linda Lane footage was leaked. The picture from 1112, what it could see was leaked. That's the stuff that was leaked. As far as court records and documents and evidence from what this guy allegedly has on his phone, who has privilege to that information that thought that would be okay? And why did they do it, right? In the Delphi case, we had somebody unalive themselves over this very thing. Leaks, real leaks in the case,
Mm-hmm.
under a gag order. And they were it was devastating information that was leaked. It was pictures of the victims,
Mm-hmm.
And there was serious problems with that. And a lot of implications, and remedies sought. So it gets very serious, especially when you go releasing what was on the damn defendant's phone. That is crucial to the case, other than a leaked footage that we're going to use in court, right? The videos, because some of them believe it, some of them don't. Believe what y'all want. It's listed in the damn court documents. They're going to use those 2 locations, and yes, they've been leaked. That is what it is. It's always been that way. If you were solely focused on the random things that were allegedly happening, then you missed that vehicle circling its prey the entire time. But the stuff on the phone, that's really not stuff we should know about yet. I mean, of course, we all want to know, and inquiry minds and want to know. We need to know, but it's crazy. That this to me, that I think the psychological aspect of it. Who the hell would have thought that was going to be okay? Like, no repercussions.
Somebody who
Did
didn't care.
Either they didn't care? Was the money big enough? What was the motive? I'm always curious to know what that damn motive was. Chris McDonough had a thought that I hadn't heard yet, some of the leak being Pennsylvania cops. Mm, I
No.
don't know if Pennsylvania cops would have access to what Idaho found in their search warrants on his phones, right? By the time PA got done with him and sent him back, they hadn't had time to get records back on Koberger's phone yet. So that was my thought on that. But I didn't know he said that, but that's interesting, but I don't know why Pennsylvania would do it and risk it. Then again, why would a Moscow cop do it or the FBI? What if it wasn't Moscow Police Department at all or Idaho State Police at all? It was FBI. Look what we can do. Look what we can do. We could also find your ass on an IGG tree and slide in the back door. And here's what else we can do. We don't really want to know what all they can do. We would probably be jaw dropping. The stuff we do
That's
know that
actually
they can do.
interesting.
What's that?
What she just said. I was thinking about it while you were
Was let
talking.
me let me have your thought on it because I'm interested to know.
Cause yeah, Rachel. Cause I was like,
Yeah,
sorry, I had the chat screen behind something else on a different monitor. But what if it was? What if somebody in Pennsylvania? Because you remember, they're the ones that went into the house.
yeah. Mm-hmm.
And everything. And
Them and
what
the FBI.
if? I mean, like, even think about it. So they bagged and tagged all the evidence, right? From the house, right?
Yeah,
And then ultimately, I would imagine they would have transferred it to the FBI because they were there too.
yeah. It's
And
state, so
then the FBI helped with the chain of custody to get it all back to Idaho or
yeah.
whatever because only Payne was there
Yep.
or whatever. So they brought it all back on that, I guess, on that jet that they
Plane.
put him on
Yeah. The
or
car. They
whatever.
took the car apart and
But
loaded
I
it all
mean,
up.
somebody could have gotten a Celebrite download like really quickly while they had it, before they put it
If
in an evidence
I,
bag or something, or I don't know. You know what I mean?
yeah, but I don't know if you can get a Celebrite download without a warrant first.
I'm not talking about a warrant. If you're talking about somebody who's interested in leaks, what the hell do they
Uh,
care about a warrant?
well, I hope that didn't happen because if the investigation uncovers that, guess what's about to happen?
You know what I'm saying? Because it's like, yeah, you already. What is that
Oh,
at my front door?
well, then they deserve what they
Oh my
get.
God!
The
Sorry.
Portburger's got a case. That's what that means. If that happened that way, and they can what?
Uh, I'm looking at a butt of a deer at my
Oh,
front steps. I just like spun around and I'm looking at this deer's
yeah,
butt. It's like hanging out at the front now. Oh, sorry.
yeah.
She scared me because like she's right by the window.
And Rachel, if it's some info they've been collecting for a while, that means there's somebody still leaking information for a while, right? There's got to be. I'm thinking it's probably one individual. Why be so stupid? I don't know. People do dumb things all the time. But as far as
Mm-hmm.
Pennsylvania goes, I don't. That's very risky, and you could blow the entire case by getting an illegal download. And if they're not under a preservation order over there, just Idaho that we know of, right? We haven't seen one come down for Pennsylvania. So if somebody did it, it went to that kind of did that and then sat on it for this long and then leaked it, and then they find out, Koberger's going to have a field day with that. So will Ann Taylor, and rightfully so. All because it was an illegal search warrant download obtained. Oh, that'd be bad. That'd be really bad, and there's nothing we can't even deny that. Mm. Dolphin Firefly says you scared me, Dolphin.
Oh, sorry. Yeah. She
Oh,
scared me. I just was like, I saw a notice, a
wasn't
notification on my
expecting that
phone
ass.
about something at the front door, and I spun around, and yeah, big old deer butt in the window practically.
Like,
You know? Hmm.
hey, those things might come right through your window. They're irritated with you because you didn't feed them fast enough.
Yeah.
You're gonna get one crashing through the front window. Y'all seen those videos where deers will do that? They'll run through the
Hmm.
front plate window of the store. I'm thinking, damn, those deers are happy living in town. Ours like the woods, but okay.
Oh yeah, or the bears that like come in and grab like a couple of things and
Yeah.
back out or whatever.
We had somebody
They're
just get one
funny.
the other day in the tree because we have a this time of year we have a abundance of bear trolling around the neighborhoods. It is what it is. Um, but somebody got one again the other night up in the tree. My brother actually got one a couple. Well, I think it was last weekend. They were on the river, trolling around in the boat at night, and sure enough, he's got a big old black bear sitting up in the tree, perched there looking at him. It's we're used to it down here. Just don't mess with them and don't come at us. We leave you alone. You leave us alone. We're going the other way. They're stalking you, dolphin. Those they done got used to dolphin feeding them. They're like, we're never leaving. They got it made at Dolphin's house.
Well, yeah, she ate and then she got up on the hill behind my car and she laid there for hours.
Yeah, they like it
Um,
there.
hmm
Shit, we all would.
And now I guess she's checking the front to see if I put anything out on the front steps
I'm
too.
gonna go live at Dolphins.
But I
It's
didn't,
fun.
so yeah. Oh, that's so funny. And I can tell it's the same one.
Hmm.
That's
Oh yeah,
so funny.
those that come out to the backfield, you could always. There was a mama deer, the doe. She had a couple of little babies, and then one day I was out there watching them, and I'm like, "Where is this buck? I know he's got to be around." And then lo and behold, one day he steps out of the tree line, and I was like, "Holy shit!" Because them hunters love a big rack, and this dude had one. I was like, "Golly, I don't know if somebody finally got him or not," and I hope not, but because he was pretty close to the house back here. I know what they do back there, but yeah, it was pretty big deer. Leave the bears alone and let them do their thing. Yeah, we have a problem here with them coming all up in the yard trying to attack people's dogs. We had never had anybody attack themselves or bit until recently. One did get a guy in the leg in the middle of the night when he went out to see what his dog was barking about. My son's old neighborhood, they had to be super careful because the neighbor 2 houses down constantly had one coming up and fiddling around in his garbage. Yeah, we have a large concentration of black bear here, and they're probably going to open up a hunt soon. We've only had one because at times they become so well protected and overpopulated. It's like it's dangerous right now because of the fact they're in so many communities. Shit, we'll find them out in the Gulf swimming sometimes. It's crazy. Same thing with our gators. If you go for years without having a hunt, you have a problem. So they open up the gator hunts like that as well around here. So I think they're about to do the same thing with the bears. I remember
So
years
glad
ago
we
they
don't have to
came
worry
down
about
here
gators.
because yeah, my dad lives on right at the where Eglin Air Force Reservation property ends. My dad's begins, and it's the largest one of the largest Air Force bases in the world, but it's heavily wooded. And Steve Irwin came down there and did a whole special on the eastern diamondback rattlesnakes because they're abundant down there. And there's also been the guys that came in, they're scientists, and they were tagging the black bears to track them because they were trying to learn their movements through the area because there's such a large population. They're like
Mm-hmm.
they built an underground tunnel on one of our back road highways because the property splits on the reservation, and they would cross the highway, and cars were trying to avoid hitting them, and it was a whole thing. So they built this underground thing, and the bears use it. It's crazy. I had one run out in front of me in front of the red light right after I moved up here. I was headed to town with my son and got all the way into town at the very first red light, and one ran out of the woods. And I'd never encountered one like that before. Hurricanes, bears, and gators. We got it all. What do y'all want? Panthers, coyotes. I love it. Yeah. We've had the bears get up into our city limits a lot, though. We had one hanging out a tree down by the McDonald's over in Pensacola one time. He stayed there for like 2 days. They finally got it to come down and did something with him. They moved him. Okay, let me see here. They're still, of course, they're still at lunch. They got almost a half hour. Let me show you. Well, let me get this out of the way. Get it together here. Okay. Okay. I have the hearing that Lori had trying to get the judge removed, and for me, it's almost like a comedy thing at this point. I want to see Brandon get the justice he deserves, and I know it's coming without a doubt in my mind. This lady's just gotten to the point where she's full ass on comedy for me. And this is where she was trying to get the judge removed. And after that, they had finished their jury questions yesterday and then had another hearing. And that's when you can tell the judge was just done with her. Like, I'm tired of treating you with kid gloves. You asked for this, you got it. Rachel says they have bears here, one across the street a few years ago, and my dumb neighbor didn't even think about it, letting her palms out. Yeah, people here have learned about, especially their small dogs. A lot of people have the ring cams front and backyard now because of the bears, and a lot of people catch them go into the garbage cans, but they catch them climbing over their privacy fences into their backyards. That's how blatant these bears have become, and the ones who do have dogs have to deal with it constantly, especially the little guys. There was one person's camera caught the bear literally trying to get the dog. And then we have ones of those little dogs who are relentless and they mean business. And bear, you better get out of here and do not come back in my yard. Like, these little dogs just didn't care. Balls to the walls. It's comical as shit, but it's dangerous. All right, guys, and Joe Schmo is over there, boots on the ground, sitting there for jury voir dire today in the Lori case. I think he's having an update again tonight with Kresha. I believe they're doing that again tonight, getting prepared for trial in that case. So let's watch a little bit of Lori's motion to get the judge dismissed and see what she got to say for herself this time.
CR 2022-00124201. This is State versus Lori Daybell. Appearances, please.
Trinity Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense.
Pamela Hicks, Advisory Council.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right.
No, I object to them. Oh, you object to them? I always object to them. She doesn't like the media. She's objecting to all media. There you go, Butterfly. I don't know. I thought he had one scheduled, so maybe they do, maybe they don't. I don't know what he's got going on. But there's Joe's link, guys. Look for it later. I think he'll probably come on and talk about it this evening. So, yeah.
The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify.
Does that sound okay? It's a little echoey in my headset, just making sure you guys have good sound.
Qualified judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in
Ma'am,
this.
I'm sorry, can you pull the microphone so I can hear you?
Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Bresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing, and I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else?
She's such a tool.
Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Boreski from this case.
Thank you. Ms. Dable, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Boreski, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing, and we had to stop trial, and I had to go fix it. And
She had to stand sideways at the podium so she could keep that thing on. Oh, well.
that is what MCSO recommended, that if that was too burdensome that they would put an armed guard in the back. And because of the media that Judge Bresky has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about.
Okay, that's the only argument she's got, and she's right. But upon further investigation, I guess they were satisfied that juror number 15 did not look you up prior to deliberation. That was the question. But everything else you said is true.
About the case.
He did get in trouble twice.
Now he's saying, well, he went on another media thing and said that he took it back. He took back what he said, so I'm not going to give you a new trial. And
Dolphin, how can we listen to her voice? Y'all know what? This lady, me and her go way back, don't we, Lori? I was watching Nate live when he tracked your ass down in Hawaii, asking you, "Where's your kids, Lori? Where's your kids?" And she refused to give them up.
This is one I would not have followed through with because I can't listen to her.
Well, we didn't hear from her. We trailed her for a long time. She was silent for a long time. So because there were children murdered, and this bitch was responsible, it looked like, I followed it, right? I'm to the point with Lori Vallow is she does not drain my energy. Because I have followed all her cases off through the Idaho. I was up all night listening to damn audio out of Idaho because we didn't have cameras. I'm over her as far as all that goes. To me, she's comical at this point. She's no count. She's trying to give herself a little, and then, the judge is going to tell her later in the next hearing, you wanted to be your own attorney, ma'am, so be it. Right? And that's where I'm at with her. Her voice, her style, her everything, her arrogance, her narcissism, it's all there wrapped up in little religious Lori with a capital R. Dumbass.
Nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible.
And I'll tell y'all something. If you think that Lori Vallow is the worst of the mommy killers and the most arrogant and narcissistic one out there, I tell you to go to YouTube and look up Diane Downs TV. That is an awesome channel. They have a wealth of information from a crime that took place in the 1980s of a mother who took the lives, or attempted to take the lives, of all three of her children. One she was successful with, the other two she was not. In the story she told, I wonder where Susan Smith got the idea for her story. Was it from Diane Downs? That is the most narcissistic woman I've ever seen in my entire life. I need to get the link and drop it because you guys have got to check it out.
Yeah, I remember her case.
Do you remember that case?
Yeah.
Okay, if you want to deep dive it and see just how deep that level went, Diane Downs TV is just, they're amazing. I've spoke to her via email because I want to do some stuff on that case because it's just so much. But she's got a treasure trove of case information out of the case. It's excellent stuff. Yeah, highly recommend it. Thank you, Butterfly.
Yeah, just like with Lori, so she's got, obviously the main trial, once they found her, guilty and
Uh-huh.
sentenced her to, I don't know, however many life sentences or whatever she got.
Yeah.
Me personally, I would have been done with her,
Oh, yeah. Yeah,
Um,
it just took so long for them to finally get to the conspiracy cases for
mhm,
Charles Vallow and Brandon, even
mhm,
though, their Charles' death occurred before the kids' deaths occurred.
mhm,
And then to get there finally, and the evidence that came out that with Brandon's case, they both deserve. I mean, they came so close to getting what they wanted with Brandon, so close. He was so lucky, and the way that all went down, they absolutely deserve their justice, and it's time for them to get it, and for her to go sit her ass down in the corner. If you want to fight for women's rights in the prison, go right ahead, Lori. Prison, you already know, is better than the county jail. Maricopa County was the worst county jail in the country you could have went to, honey, and you got welcomed with open arms, and you don't like it. Go back to Idaho and finish your 3 life sentences there first. Go back to what you know. Although she's fighting an appeal in Idaho, the last movement in that case was a few months ago, is at a dead ass standstill because she keeps asking for extensions.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let.
She was talking about Nephi in court that day, and the judge, I forget exactly how the exchange went down, but he said, well, yeah, but if you're going to compare yourself to biblical figures, she took that as a slap in the face against her religion.
Let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
Nope. She's like, nope. She got even ballsier back before the actual judge, because that same day she had to go back before him that afternoon. And I'm just like, this judge, this guy and his patience level, right? Could you imagine if Hitler was her judge?
Oh, yeah.
He's willing to call Cyril a conspiracy theorist, and at a hearing, ain't no telling what he'd tell Miss Daybell.
Mm-hmm.
He'd tell her more than come with a legit merit in your motion. He would say, your shit ain't even admissible, ma'am.
Mm.
Oh my God.
You're gonna make me get up, aren't you?
Who, the dog?
Hmm.
Was she
She's
being?
been sitting here kind of like barking and chuffing.
Uh
Uh, the next door neighbor has some sort of van that now all of a sudden, I don't know, I'd say the past year or whatever, he's been
oh.
using his backup beeper. So, and it reminds her of, all the transportation,
Oh, yeah,
ambulances that used to bring my
yeah,
mom.
for your
And
mom.
so she, starts to chuff. And I'm like, no, it's next door, next door. But
Yeah,
I don't know. Then I thought I just heard something too. So I was like, let me get up. So that
yeah,
was beyond that. So, yeah.
right. That dog hears things because I trust
Mm-hmm.
my dog when they hear things, right? You're gonna hear it long
Mm-hmm.
before I do, and I know that. My old dog was such. My husband worked at night, so that was my favorite thing about her. Is if I thought I heard something, I'd look at her and see what her reaction was. If there was a reaction, she heard it too, or if she got up to go investigate.
Yeah.
I'm trailing her. I'm like, "What are we looking at?"
Generally, we look at each other at the same
Yeah,
time.
exactly.
So,
We're looking at each other. We're
mm-hmm.
like, "Do we need to get up and investigate this further?"
Mm-hmm.
I'd always let my dog take the lead
God,
on
it's been
that one.
so dreary today too. Mm.
It's tried to get that way here a little bit.
Mm.
It started out sunny, but now it's looking like I don't know what I want to do.
Yeah.
I don't know.
Okay, I'll be right back.
Okay, I'm checking the Stearns docket real quick while we have a moment. They still have the fans spinning. I got the feet up on the side, guys. They should be back in around 10 minutes or so if they're on time. Well, I guess the judge in Stefan Stern's case, for some odd reason, has taken his ever loving time ruling on those motions to suppress. Are they that difficult? Why is it taking so long if it's going to be pretty cut and dry, right? Is he really considering it? I mean, golly. I don't like the not knowing. I don't like the unknown. It makes me nervous, especially if a judge takes too long on a decision. That makes me really nervous. That means he's considering something. The garbage, but you can't have them garbage people stealing the trash. That's dog's not having it, right? I have to be on top of it when the garbage man runs here. I have to go get those cans because we were right there on that highway, and if I leave them out there, the semi ride by and throw them babies all up in the street. Then I might have to be responsible for a car crash, and I'm like, not even having it. My dog's gotten used to the trash man, though. She doesn't freak out when he comes. Sometimes, if she's sleeping, he'll startle her and she'll bark out for some odd reason. He's supposed to rule in June. God, it's almost June, right? It's almost June, dude. Come on. Well, we got another day. Was there 30 days or 31 in this month? 31. One. My granddaughter has a birthday in like 5 days. 8 days before Kaylee's Gonzalez. 9 days before mine. Yoo-hoo. Yeah, Rachel, you mentioned your mom. Listen, you knew about the case of Diane Downs. You heard your mom talking about it. That's one of the first cases I like followed true crime wise because of my mom. Right, I was like a preteen, and my mom was into watching politics and watching true crime and injustice for the people who got injustice. That was like one of her things. I'll never forget. I always remembered that, and she's always for the underdog and things like that. That's how my mom rolled. But I remember watching the Diane Downs stuff with her and her getting those updates on the nightly news. Because back when I was a kid, we had all this fancy cable TV, news networks, 24 hours of stuff. No true crime community. We just had the evening news and 2020 or whatever that was going on. Um, oh, thank you, Butterfly. I always don't think about mine until I go look and see what day my granddaughter's is on now. Because I'm thinking about her and like, oh yeah, okay, that's how many days. Because sometimes I'll have a little cookout and we'll do mine and her little birthday cookout together. I think I'm gonna do that this year. Have them all over. That's why I need to get a new grill. I'm ready to get my grill on big time. I've been kind of working on a little outdoor kitchen type area out there. Started that last year. And you get out there and finish it up. You have to pick your times out here in Florida. Get out there in the late evening. Otherwise, you're going to be steamy. But I'll take it. Can't get out there in the winter and do all that. Okay, let me check the. We still got the fans spinning. It's Friday. Are y'all looking forward to the weekend? I'm looking forward to go over and getting some Camp Shorty time in this weekend. It's always a fun time over there, and she does great recaps on the Karen Reed stuff, and you can just get in on a conversation. Y'all know me; I love to conversate.
Okay, I'm back.
Cool.
Oh, is she done? Or,
No, no, they're still at lunch.
oh, cool. Let's see.
Yep, they still are at lunch. They got a few more minutes. Rachel, you girl, mine just had a birthday in May here in May a couple weeks ago. He
36. Oof.
Yeah, my kids are that old. Well, two of them are. One is
Mm-mm.
I got an 18-year-old, then I got my two mid-30 kids. They both just had birthdays, my two oldest kids, March and May, and they are like in their mid-30s, and I'm like, holy shit. I remember when they were babies thinking, what would life be like when they were in their 30s? Well, now I know. Thank goodness I'm still here to see it and enjoy it. And then my little 18-year-old who's getting ready to fly the coop, I can tell it's coming. He's focusing on trying to figure out what he wants to do as far as college goes and all that.
Mm-hmm.
Yeah, his little
What's he
girlfriend.
interested in?
I really don't know. He just had some testing done at school, and the school he goes to is a long way from my house, but it's like the top school in the county and one of the top in Florida. And
Mm-hmm.
he's top 5 in the high school in his scores, so he can pretty much do whatever he wants. But I don't know what he wants to do yet.
Mm.
I know he loved it. Just I don't know. I think he's got a lot of things he's interested in, so I think he's got a lot of good options. My grandbaby getting a little loud on that little VR thing in there.
Yeah, I was gonna ask, what's he playing? I'm
Uh,
gaming right now myself.
the Gorilla Tag, I think, is one of the ones he plays all the time.
Gorilla Tag. Gotta look that
Yeah,
up.
he plays on that. He got that VR headset for Christmas, and it has been on.
Mm-hmm.
When he first got it, it was so crazy to sit there and watch. It's still funny to sit there because he plays in the living room where you can keep a good eye on him and monitor what he's doing and talking to and all that good stuff. But it's just to watch him play that thing is crazy. The way he's moving
No.
around and doing stuff.
Mm-hmm.
I'll say, "What are you doing, dude?" Well, I'm
How
trying.
old is he?
He's 9.
Oh, okay. Mm-hmm.
Yeah, he's only 9. I remember when the things he's telling me now that his dad's getting used to because he's got a little gamer kid on his hands. I'm laughing because my 18-year-old, I done went through all that. I know about buying skins and downloading new maps and all the things. I know how much money I paid Microsoft over the years. Lord,
Yeah.
my son's learning with that VR. And they play the Roblox. I don't know what all he plays. Fortnite, that's one of the ones he plays.
Oh, yeah.
Well,
Mm-hmm.
all the classic whatever the kids are playing right now, he's playing them. It's funny. And to hear them learning to be social like that, but also trying to teach him online safety at the same time.
Yeah.
We do not ignore that, or I don't. I didn't with my 18-year-old when he was becoming, because, it was different when my 35-year-old was a kid. Gaming wasn't like it is right now. My
No.
kids had a
Mm-mm.
gaming system, but it wasn't online action, right? And then with my other kid, 18, everybody's like, oh, that's going to ruin the kid of America. Well, I didn't feel that way. I'd done raised a kid without it. Now I'm raising one with it. It is totally different. Yeah, but you can do it, right? And at
Mm-hmm.
least I knew where my 15, 16-year-old boy was on a Friday night.
Yeah.
versus not knowing where my child was. And if he was in there blowing somebody to pieces on Call of Duty, then oh well. I'll I'll take it, girl.
Better there than in a mall, right?
He's in that room cussing up a storm, cussing somebody out at 16, and I'm just like ignoring that shit. I'm like eating my snack, watching my true crime. I know where my baby's at. He's in there cussing some fool out. But
Yeah.
I'll take that over that street stuff any old day. But online safety is, a talk we should all have with kids who are online. It's always a good opportunity to have it. Now, I'll hear him sometimes getting a little aggressive, and I know that boys will be boys kind of thing, but I'll also talk to him about that at the same time and let him to come to some conclusions on his own a lot of times. Crazy wind on the way for Rachel. Uh-oh.
Yeah, it just
That,
started raining here.
that's tropical storm force gusts where I'm from. 35-mile-an-hour sustained as a tropical storm force wind. That's a pretty heavy breeze, isn't it? Oh goodness. It's not good when our boys or even our girls, they get somebody we don't care for up in their life. Ugh. I'm glad I don't have that issue. Well, yeah. Glad I don't have that issue. They should be coming back soon. And maybe they'll get a full rest of the day in, you know what I mean? They're all just get it on. Let the content flow. Let these defense attorneys do their
I doubt
job.
it.
Let
Yeah.
them let them do their jobs, and everybody quit being so rude on the prosecution side and these hostile defense or prosecution witnesses they were displaying around.
Yeah, that was Hank. That was for the up for the prosecution earlier.
Yeah, and just
Yeah, I'm serious. If I were a witness, I probably would just ask him, look, sir, please don't take out the fact that you're doing this case a second time, again
yeah.
on me. You know what I mean? Because like what he's asking, the way he's speaking to the guy is kind of unnecessary.
Very unnecessary. He made a couple of really smart, quirky comments that he should not have made. And he knows he's smarter than that guy. He knew he shouldn't have made those comments. Even
Hmm.
questioning him do you understand this? Like, dude, are you serious, Brennan? After what you put on the witness stand in Burgess, and
Yeah,
that whole fiasco that we witnessed, you got the nerve to ask this man about does he understand something? He
yeah.
actually holds the degrees he claimed he
But he's
held.
just trying to make him seem like he's lazy though, or whatever, because he didn't write any reports or whatever.
Right. He was not he was
And he
there
didn't
to
go do the work and all
yeah,
that, and
he
yeah.
was not brought on it for all that. He was
Hmm.
brought in so far late in the game, all he was asked to do was evaluate their reports and is this their conclusion accurate on your opinion? And I'll tell you, when you go look at Burgess's credentials versus the credentials of DeSorga, I'm going with DeSorga. I watched that entire video yesterday. I'll link it after here in a minute. I'll go
Hmm.
get and link it. It may be boring to a lot of you. It's a couple of tech guys talking about cars, but if you listen to the content of the conversation,
Oh, you're talking about
you
theirs, yeah.
yeah, you understand what Disorga does for a living and how some of this stuff they're talking about works, like the EDR, the event recorder, because that absolutely is why they brought him on. It was the whole purpose. So I was far more impressed with his education, his background, his training, and his record overall than Burgess. And that's, again, not my fault. It's theirs because they had a shitty ass guy. And we saw the guy misstep all over himself there on the witness stand. It was a complete fiasco for the prosecution. And they cannot recover from it. I don't care how Brennan wants to get up there, and you can't get up there and cross the guy on just that merit. You got to get in those stricken comments. You're over here objecting to every line of questioning the defense has to offer. To they
Yeah,
have
that's what I was gonna ask. How are they objecting? Because half the time I don't even hear,
oh she don't allow
the
it.
Commonwealth say that they objected. I hear her sustaining, and I'm like, wait a minute, did they even object, or is she just doing it?
All they're allowed to say is objection. Not nothing, no reasoning behind it, nothing, and she's gonna say what she decides, and that's it, end of conversation. And we've already heard that the jury had an issue with that because
So
sometimes
what
they
does he
wasn't
just do?
here.
Hold up a paddle or something? Because
Yeah, he's
like
over there barely speaking.
literally, I have
Yeah.
hardly ever heard him say anything.
Yeah, he's over there barely speaking, and you'll notice sometimes when these witnesses, and I've noticed it's a pattern, and it started with Jen McCabe. When these witnesses are testifying, the prosecution's witnesses, certain things that the defense would ask before they ever attempted to answer the
Oh,
question,
you're talking about them looking over?
they would glance at the
Mhm.
prosecution because they expected him to object. He
Mhm.
already, they were super heavy prepped for this trial. Each and
Mhm.
every witness up there. Here's what they're probably going to ask you about, and here's when I'm going to object. Don't say a word until and wait for me and the judge.
Mm.
My signal. So yeah, it became obvious to me, especially when you see the witness look at the prosecutor like, "Are you going to object now? Do I answer it? What do I do?" That's what I was. Mm. Butterfly. I knew that was coming today, right? Did you get?
Arrest in the Lawson case for Crystal
Yeah,
Rogers.
it's the
Oh, okay.
case. Yeah, the case I'm following in the evening. This is very short. This trial is very, very short. This is a conspiracy case, and the
Mhm.
two conspiracy cases are being laid out ahead of the murder case, which is beautiful because we're seeing the story that's going to come for the murder case. Let me see if
Mhm.
I can find Crystal. Um, good, good Butterfly, because I'm going to get my updates on that later. I watched some pretty decent ones last night. Did you get to see any of those? So I figured that was happening today. Um, Crystal deserves it. Damn it. Her dad deserves it. Her whole family deserves that case to finally be brought to justice. And I can't wait to see what's going to happen with Nick Hauk, where they're going to, are there charges coming, right? For the mom as well, Brooke's mom. That case has a lot of intriguing moving parts as well. It's just not, and it's not that Kentucky is corrupt on this case, it's the family, right? The small town and the family who seem to own the town versus full on police corruption. Why are the police corruption part a thing? Because one of the players, the brother to the man accused of murder, was a cop. And there's another death of another officer that's under extremely suspicious nature. Jason Ellis was a cop, ambushed and killed, taken out. And is it tied to the Brooks House situation? There's a lot of questions with that case. Not to mention a mother and daughter case right there in Kentucky as well. So then you got the other shit in Kentucky with the sheriff who shot the judge, that whole fiasco happening. I don't know. So they severed from what I'm understanding, Butterfly, the Lawson case right now, Steve, or do I have the names backwards? Father and son. Daddy's on trial right now. So the son goes on trial next, but I don't think they severed his and Brooks' case. I gotta, I gotta shut my door. The kid's getting loud. I gotta go and check Shay McAllister's reports on that because think I knew they wanted to sever all three of them, and I thought they did, but now I'm thinking they only severed Steve's. So I've got to check on that. Uh-oh, they're zooming in and out on the camera. Yeah, I got a Crystal Rogers channel in the Discord, and that's where I've been dropping the links to the updates so I can keep them all in one place and organized until I can get back to it. Because I do want to, I'm probably going to talk about it on Sundays live.
Oh, that reminded me. Have they heard anything on Sebastian Rogers?
Nope.
No? Okay. Is
Nothing
everybody still
new.
all over it, or did they finally
Whenever you're
ease?
ready, Mr. Cannon.
Yeah, the crazy people are still all over it.
Shit.
Or all over each other. I don't know I don't even know how to put that. I don't pay
Mm-hmm.
attention to any of that, so I don't know.
Mm-hmm.
But as far as the actual case itself, nothing.
Okay.
Ms. Gilman, if we could turn to page 6
Oops.
of Mr. DeSorga's amended PowerPoint presentation. Sir, I want to ask you about your opinions, and inevitably some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is, with the other chips, part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report, where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Sustained.
So when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, You have no other independent information to suggest that the power on, power off event in 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I know,
shout.
that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
Okay. The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key-on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key-on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key-on event in a Lexus infotainment used in addition to the key-on timer from that same Lexus.
You know Mr. Burgess actually looked at the data, not just the timestamp. He looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point. It's a derived value from the key-on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3-second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3-second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key-on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
your
this specific Lexus.
I'm sorry. Finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems, that key-on timer is basically simultaneous with the key-on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. Had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same, or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Ms. Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct, and that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now, let's turn to slide 9. As part of your charts, could you enlarge to the left, please? As part of your charts, you took this chalk from Attorney Burgess's report, and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied the numbers in his third column to the times, so, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m. You said on direct examination, oh boy. You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart, so
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion, that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matched to John O'Keefe's iPhone or some other phone matched to John O'Keefe's iPhone? Did you do any independent study about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m., the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 calls. Do you know where that information came from?
It came from the SD card from the infotainment.
Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
Do you know the genesis, the source of those 4 numbers?
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from the defendant's phone to Mr. O'Keefe's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
between. Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So,
Do you know where those calls came from? The source.
a phone.
Whose?
Miss Reed's phone.
Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, when you plug your phone in, it's going to register on the infotainment system, but come from the phone? Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure. If there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone is plugged into a car, it downloads the information from the iPhone onto the infotainment system? Did you know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a part of it you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection,
but
Your Honor. So I'm going to strike that. Go ahead and ask your question.
My apologies. If you have two different devices, a Lexus clock, the entertainment system, and an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, do you agree that you would expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
Two iPhones?
Yes.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely two iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other?
Objection. Sustained.
Do you have any opinion about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, do you agree all of your assumptions and conclusions are inaccurate?
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the answer.
Don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Sustained.
So this is iPhone to iPhone. Then your assumption on this first 5, 1, 2, 2, 1, 2, 1. If they're iPhone to iPhone and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they? Objection.
I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they? Objection.
Sustained.
At 5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Birch's report as I recall it, in that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed. There were 2 call logs in Mr. O'Keefe's phone, but only 1 timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
If these are 2 separate calls, can you explain to us why there is 1 timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar vehicle, was it?
This table, no.
This information was taken from the infotainment system of the defendant's car, isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone, isn't that true?
Yes.
And so, you know why there would be 2 phone calls and only 1 timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Did you know that?
Yes.
Well, if you know that,
He just told you that a few minutes ago.
that even though there's 2 calls and only 1 timestamp, that's because how the infotainment system works.
I think that's the most logical assumption, that that's how it works.
So when you look at 530.15, bottom middle, and 530.52, it is impossible to tell which one relates to the 530.31 infotainment on the left to compare. It's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
I'm not sure I understand the math.
530.31 is 16 seconds different than 530.15 on Mr. O'Keefe's phone. Yes?
Yes.
530.31 is 21 seconds different than the 530.15 phone call. Yes?
Yes.
And the difference is cut each way. One's minus, one's plus.
Correct.
So when you add those disparities, you get 27 seconds, don't you? Objection.
I'm going to allow that.
No.
Okay. What do you get?
You're saying, if maybe so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
how many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the defendant's car was turned on at 5:07 a.m.? Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable, yes.
But when I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay. If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
If we turn to 10, please. Given, could you zoom in a little, please, on the left? Given that these data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30, did you consider whether they would be less reliable than comparing to the triggering event, the three-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:30, 1:43 to 48, than the three-point turn?
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically, but I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy, or would you like me to bring it to you?
Do you have the reports with you, sir?
They're not.
Okay. Do you have an extra copy for him, Mr. Brennan?
Mine is marked. You want me to show the mark? Let me see if I can get a clean copy for the witness. January 30th. So it's just marked. I don't have a clean copy. I don't want to show you something that has my writing on it. Not that I care that you read it, but this protocol. Okay. In discussing why this is not an effective way of matching the time, did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes.
And when
Call
he's
logs
talking-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 5:30-31.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and not be assumed to apply to other timeframes stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see Councilor Tadmore.
Where'd Salty go?
I had to go to the kitchen to put my dish up.
Oh, okay.
I did. I was in there putting my salad bowl up. I had made myself a nice salad, and I was eating it. Yeah. Grandson's waiting on his game to update. Yeah. Come on, Brennan. It's like, dude, give it up. You're not gonna. Oh, my phone volume's up. You're not going to be able to discredit this witness much at all, if any. You so far you haven't. I mean, you can't come at his education, you can't come at his training and all the things. You're trying to break down his testimony. Not working.
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean copy?
You.
You can turn to page 3. What I read to you was where it says clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only two data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Okay. Because you still are under the mistaken belief that
Sustained.
you still have the opinion
Mistaken
that the
belief.
first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, But it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
So if we put up chart 12, page 12, please. If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to 14, please. And if you could enlarge, well, I don't think you can enlarge it. If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the three-point turn event 1162-1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea. Not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head. He put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Okay. I have Exhibit 192A. Okay. Let's start with 192B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event as timestamp 154, that actually is at the beginning of the 3-point turn? Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction, towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
Okay. And it notes that...
So ask it differently, Mr. Bowman.
Does that heading note the start of the three-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the three-point turn maneuver.
And then the heading of the change, end of three-point turn to O'Keefe's home, 12:24:07. You have any information to suggest that's not spot on accurate?
I did not analyze the three-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the three-point turn conclusion. Did you consider that?
I'm going to allow that, yeah.
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the three-point turn.
Yes.
Based on Mr. Burgess's May 8th report, and based on the data which you don't contest, you now agree that 154 was not the end of that three-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. If you could open that. The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Objection.
Sustained. Strike it.
In the final exhibit. Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range? Objection.
So ask it differently, Mr.
Okay. You suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a.
This data from the green beginning of the three-point turn, and then the orange is at the end when the car is already in motion at 11.2 miles per hour. Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
Do you have any reason to test the accuracy of this data that's been broken down? Objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, a wider range, right? Even though this analysis depends on the end of the three-point turn, wouldn't you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the three-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct.
And so if Aperture's position is the matching times at the end of the event, by going back to the beginning, isn't that even more forgiving than the 8 scientific objection?
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
Right.
The opposite of cherry picking, right?
Sure.
Do
you have an opinion to a reasonable degree of forensic data certainty about whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's 19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
Thank goodness.
What a jackass.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could.
Yep, rehabilitate your boy.
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree?
Yes.
And you hold a master's degree?
I do.
You ever lied to anybody about that?
No.
Nice.
Mr. DeSogra, what is the
Yep.
only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report,
So-
the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would. Thank you. Yeah, there are a lot. I would have to really use my finger to count them all.
Okay. More than 8?
Total after 1162-2?
Only on the 29th.
There aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, correct?
Yes.
May I approach?
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you. I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12/32/09 to 12/32/16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time with, let me rephrase that, all of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you. If you were told, let me give you another hypothetical, if you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12:33:14, would that impact your opinion in any way?
Objection.
Sustained.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess...
Hold on.
Of course.
You need to, you know, we have to turn the fans off.
And I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
Get him.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data, or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing, where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch? Click, a stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
It has a clock.
Are those two things independent of one another?
Completely independent.
are you doing with regard to the 3-second delay as it relates to the key-on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two, and that's where the 3 seconds comes from. These are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DeSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolk? Thank you. Did you create this table?
No.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
It was. It was a screenshot.
Thank you. Screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes.
You didn't type anything on this.
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection.
Sustain.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustain.
That's okay. It's out there.
May I have just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down. What was your entire analysis predicated on? What was it based on, the foundation of it, as you explained your analysis to this jury during the course of the day?
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No.
Did you change any of their analyses?
No.
Did you explain their analyses?
Yes.
Sustained, ask it to.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and your presentation to this jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes.
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
That's correct.
You were also asked why you believed Mr. Burgess did a quote-unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes.
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting?
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
What else you got, sir?
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on. Start the
It's
question
cross-examination.
differently.
It is. It has to be a question.
Go ahead, Mr.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, turn on 10 please, when you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides itself or resides on the infotainment system, correct?
There's a transfer of data. Yes.
And so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's...
And so when you don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports, and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning quarterbacking somebody's report.
Objection.
So I'm going to strike it, ask it differently,
If
Mr.
you
Brennan.
actually did the analysis yourself, you wouldn't have to make a presumption that it would be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the
Objection,
testing.
Your Honor.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No.
Did you read Ian Woodman's report?
No.
You don't know if that testing was done, do you?
I don't.
Objection, Your Honor.
I'm going to let that stand. Next.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer, frankly. I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis, then the final analysis is going to be wrong if you have using the wrong data. It's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Yes. That's,
Okay. If we could have Mr. Welcher's 33. If you could open that up, please. You were asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds, right, in those first couple of lines, yes.
Yes?
Yes, I see vehicle speed.
If you go to the bottom, at the end, the car is still moving, yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving, yes?
At the end of the record, there is a vehicle speed, the car is moving. That would be my assumption.
Okay. And so, when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data, yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window, yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay. And so after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12/32/12, which is in the 10-second window, and 12/32/16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay?
12/32/16 wasn't just that Mr. O'Keefe's phone was moving, there were steps being taken, correct?
I didn't review the phone data, so I don't know.
Did you review anything to indicate that the steps were taken over the course of 83 feet?
Objection.
So that's sustained.
You were asked just a second ago, what about the data? What was wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DeSoger, you are all set, sir. So you can step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
You think she'll call it a day or let him roll for another 30 minutes? Call another witness? I don't know how.
Oh, she's gonna call it.
Yeah.
Mm-hmm.
Which, if I was the defense, I wouldn't be mad at it. That gives me the whole day to go at my new witness, right? Versus a few minutes and have to stop. I think they've put this guy through enough. He's done. He's ready to go. It's like, I don't ever want to come back in here again for all these people.
Mm-hmm.
That was ridiculous. The way that the prosecution was trying hard, but it's like,
Yeah, someone needs to tell Bev, you could at least protect your witnesses, how they're being treated on the stand.
yeah, because she sure
Shit.
protected the state's witnesses in that nature, in that sense. She certainly did, but she's not willing to do that on the defense side here, and it's clear. And she did it multiple times with other witnesses, smiling at them, give them all. Look how much leeway she gave dumbass yesterday, in the 2 days he was up there. But
Yeah.
all this for Brennan to try to establish this guy's not intelligent enough to know what he was doing. Well, we feel like Burgess wasn't intelligent enough to do what he was doing, right? It's all it comes down to is which expert is more believable, which one has the better credentials and seems to know his stuff better. So far, this defense expert knows way better than that prosecution guy did. Um, yeah, Frank, you don't agree with something. That's not surprising, is it? Not surprising.
Yeah, I kind of do wish he had, at least written a report or something, a
Well,
little
yeah.
bit more.
Well, because he didn't, he didn't extract the data, he didn't remove the SD card, he didn't do all that stuff. He evaluated what somebody else did in their reports,
Jurors,
and he obviously wrote something
we
about
did
that
that
down.
to have me decide whether I'm gonna let you go home now or not,
See?
and I'm going to let you go home. So that 5 minutes that just took means that you get to go home, because we know we'll be longer, we don't wanna do this.
Yep.
Okay? So,
He's
we're
gonna
on
let.
break for the day. I have to give you those same cautions. Please do not
I think they've
discuss
got
this
something they're
case
going to
with
discuss.
anyone.
I can
Don't
barely
do
hear
any
her.
independent research or
She's
investigation
not saying
into
anything
this
half the
case.
time anyway.
No, I
If
mean
you
about if they
happen
were
to
going to
see, hear, or read anything about the
have a little
case,
open
please
court
disregard
thingy
for
like they
this note.
commonly do
Additional
sometimes.
caution, please be very careful.
They'll send
Continue
the
to be
jury out
careful
and have
with
a
your
little
social
discussion
media use.
sometimes.
We will see you Monday. Monday
Sometimes they
will
don't.
be a full day. And we'll start right around 9 on Monday morning. So we'll see you
Right,
then.
so
Have
Joy,
a
he
great
did. He
weekend.
showed
Mr. Rice, the
he's
jury.
so much more professional and polite, especially compared to Welcher and his combative nature. It's crazy. Because I'm just looking at that fairly, the way she's treated the other witnesses compared to this one was very, very, very different. And like I said, I gave her all the leeway I could possibly give her.
We'll come back. I'll come back in 5 minutes for the voir dire.
They're coming back in 5 minutes for voir dire. I thought that's what she was saying, something about that. So I have to pay attention to Bev's low talking ass when she's not mic'd up. So they're taking a 5 minute break and then they're going to have some voir dire stuff going down. Yeah, I knew when I watched that video on him yesterday, he was going to be a much better witness, not so combative in nature. He got aggravated a few times with Brennan's line of questioning, with the insinuations he was making, because you were almost going for a personal attack, right?
Shit, almost.
Yeah, I mean, well, if we're
He
giving
did.
way, he did exactly, and so of course that's going to get a rise out of somebody if you're coming at me personally, you're attacking my intelligence here, you know. We don't like that. I just realized you were up in here in my room, son. I just turned around and saw my grandbaby on my bed with his headset on. I'm like, where'd you come from? I didn't even see you walk past. Sorry. I was probably taking a note or something.
So I wonder who they're getting ready to voir dire.
I don't know.
Who would be their second person? Maybe a phone expert.
Well, yeah, if it is, it's going to be Maggie. What's her name? Gafferty. Let's see. Maggie Gaffney is on their defense list, and she is listed as a digital d digital forensic examiner. So I don't know.
Oh, okay.
Yeah, that's who she is, and she is on their witness list. So, because when I looked through the updated list last night, I was looking for what these experts did, who did what. And that's what I came up with when I found out, Desorga is on the list. And that's what Karen had said leaving court yesterday about him being the first witness. Then I realized what all he could do. And I was like, oh, okay. And then that's when I looked to see who else on that list, besides the ARCA guys. And yeah, she's on there as their digital forensic examiner. So I don't know. Some speculated she may be called after him because, there's a big question about John's phone. This guy just got hammered.
Mhm.
Are you a phone person? He's not. He does
Mhm.
nowhere on his CV or the website for Delta V does it say he's anything to do with digital forensics. Phone.
Right.
That's clear what he does. So maybe they're bringing her in to back up that part of it, because they're wanting to confuse these two things, phone data versus the vehicle data. Which one's right? Well, we'll take the one that we like the best. If the phone data, if it was opposite, they would have switched it. If this data lines up better to what we need it to, we'll just switch it and say this is the most accurate clock. How do y'all know which clock? I get it. Y'all tried to time it up with all kind of stuff. Who you talking about? Burgess finding data? He found an SD card. That's basically his job is to tear apart the box, right? And then he'd come up with the other ideas because that's part of his training too. But yeah, he found that I know I listened to the testimony carefully and took meticulous notes, especially on Burgess and Welchers. I don't know, Dolphin. Let me check. Yes, you did. Yeah, you did. You're back. Can you hear me now?
Yep, yep, thanks.
Dropped you. Sorry about that.
No, that's okay. Oh, the question that I have though now is, so Hank, the guy for the Commonwealth who was doing the cross for him, kept asking about iPhone to iPhone, and if you plugged an iPhone into that infotainment center, and talking about the clocks syncing and stuff like that. So I'm just kind of like, um, I don't know like exactly. So the infotainment center. Wait? She didn't have OnStar, did she?
I don't think so.
Because I'm just wondering. Okay, the infotainment center is getting its timing information from somewhere, but then if you connect the phone via Bluetooth, I
Hmm.
guess it does get it from the phone.
You would think so.
So,
Hmm.
mm-hmm.
And like the event data recorder, that SD card came from that device and not the infotainments. Yeah, so there's like different,
It was on the motherboard.
yeah, all of that. There's so many different components to it, right? And that's why they had that block of missing time to begin with, which was found
Mm-hmm.
on that SD card, which is legitimately there, and he did find it, but it's interpreting the data on the card, and that's what it comes down to right now. Which one of these experts is correct on their calculations and their data? Who's interpreting it the right way? And that's what Brennan kept trying to say is, do you understand? Did you look at this? Did you actually do the testing? How are you concluding what you're concluding? Because it's different than what my expert concluded. Which one of you is right? It's up to us to
Mm-hmm.
decide. It's up to the jury to decide now which one of those two held the more weight. And I feel like the defense so far, he's been way stronger than Welcher and Burgess, only because they had a lot of issues outside of just that how they did data. They were so arrogant about it, and so they just it was just they didn't seem very confident in their own stuff. You know what I mean? That they felt like they had to defend it like hardcore.
Mm-hmm.
You just get up there and explain your process, and then let the jury to put the weight on which one made the more sense.
I think that Dr. Welcher didn't appreciate being questioned. You know, not like just the actual, you know,
Yeah.
trial process or whatever, but I'm just talking about his methods and all that. Like people actually questioning that. I think he was kind of put off by that. But yeah, cell
Oh yeah.
towers. Yeah, Frank, but the cell tower, so yeah, your time on your phone automatically syncs to that. So that's sort of, takes that out of the equation. I don't know really what else they would need to get the cell tower data from or whatever because they know where he was. He was at the house, whether it was inside of it, outside of it, whatever. Um, yeah, he did annoy the hell out of me too. So yeah, now I want to hear more phone data too,
Oh
especially the health information. When they
yeah.
were talking, you guys said that they said something about some steps were
Oh, they did.
logged.
They said a lot more than just there was a yeah. It was a whole thing.
Hmm.
There's two set. There's two sets of stair inclines, two separate events, and there's that has to be explained to a lot of people still. And I think the jurors haven't forgot that was said by
Hmm.
the prosecutor's defense team. And then how those inclines or flight climbs occurred is what the prosecution's trying to downplay to inclines in the street.
But you know what though? Like a phone should be programmed to ignore those inclines and whatnot if you're traveling, obviously faster than a walking speed, you know what I mean? Or
Mhm.
like a running speed or whatever. So it should know that you're in a car
Yeah, you would think.
and not factor those
Exactly.
things in because I've never had a smartwatch or a phone that would,
Accidentally thought you
register. Yeah, if I
saw Dr.
drove in a hilly city or
There.
something like that. Because think about it, people in cities like San Francisco, their data would be all jacked
Right?
up,
I
if
thought
that
about
were the case.
I thought about that. What do folks in San Francisco do? What do people who live in the
Hmm.
mountains do? There, you got to climb a mountain just to get to
Yeah,
your house, right?
exactly. If you already live at an elevated point,
Uh-huh.
Oh,
Mhm.
he says the stairs can be explained. Okay.
Okay. Yeah. By who? Because I've heard them try to explain that. I know what the expert testified to, and I heard his justification. He rode in a car from the waterfall to 38 Fairview twice, once with the phone in his hand, once with the phone on the docking station, and he recorded them flight inclines as going up and down elevations in the street. But no sauce, dude. Not buying it. Plus, I saw an armchair experiment on court TV. It didn't register on their iPhones. They climbed stairs, taking the same exact route. But when you listen to the experts come in and testify on the prosecution side, the man appears to have taken steps up and down, right? And he also appears to have went all the way up to that front door at some point. But now
You
that
are unmuted.
their other experts come in and just cancel that shit right out, and they want me to forget that, and I can't. I got notes on it, actually.
Floor is now open, maybe seated.
You solemnly swear the evidence you give the court in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God.
Thanks, Frank.
Thank you. I know this is a reluctant opportunity. There is a witness outside.
Who's Bonnie, Firefly? Who's that?
Sure, is she right outside the door?
Oh, yeah. That's what I'm
Do you-
talking about.
sure. Do
Danny
you
and
mind
Cody
if I-
did it.
You can stay right there, and it'll just be a few minutes, okay? Ms. Giannetti, when do you need this witness back? Monday?
So Cody went up and down the stairs at the hotel, and it absolutely registered his steps. Then when they got in the car and drove, both of their iPhones tested it, and neither one showed inclines taken. Crazy. Yeah, Vinnie Bolotan. I think we showed that here on the stream.
So I'm going to need her at a microphone. Do you have one on council table there?
She can't come in the room? What's going
So
on?
the podium, or one of those, back where Eugenia is, thank you.
Is this the Maggie person that you guys are talking about?
Hell if I know. I don't even know what's going on. Of course she needs a microphone. Why are we hiding this lady?
No, there's a microphone a little closer. We're just follow the.
What? How old is
What do you mean
Hi,
special
good afternoon.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day?
Yes.
Okay.
All right, so we're not going to reach you today, unfortunately, but you were summoned to be here?
Yes.
All right, so that summons is still good until we reach you, so you're going to have to come back Monday morning, okay?
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay, thank you very much. We'll see you Monday morning. Be here before 9, okay?
Will do.
All right, thank you very much.
Thank you, Your Honor.
That was weird.
Is she on your
Go ahead,
list?
Mr. Alessi. Oh, geez, you
What was her name again?
Kelly Dever?
That was a big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis.
maybe Canton Police.
Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him, essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this old guy.
Can we turn off the fans and the air conditioning?
Lifelong Proctor friend.
We're just going to do that, sir, so that we can...
Yeah, I just sent you something.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduate high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes.
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay?
Okay.
May I approach?
Yes.
Would you like this marked for identification first, Your Honor?
Yes.
Exhibit N for identification.
Now we'll do it back to the witness.
Thank you.
Oh, okay. We'll bring on Miss Kelly.
And what's this guy's name? I missed it. I was looking up some stuff.
Yeah, I forgot his name.
Anybody in chat hear his
We're-
name?
Dolphin and I are over here reading stuff on the side. I don't know his name either, Dolphin. Sorry, guys. We're not being great hosts right now, are we? Ooh. Yeah, Firefly. Ooh. So it appears that Kelly Dever, maybe a former Canton Police Department officer, now a Boston Police Department officer, and maybe she was present during the Sallyport video, our little inverted video. Did she see something? Interesting. She's the only cop to be called by the defense that the prosecution didn't call. Oh, he had some interesting. Let's hear some Proctor text. We had to hear all about Karen's text. I want to hear Proctor's too.
Oh, they haven't brought these up? Oh, here we go.
They did about the
Jonathan
things he said.
Diamandis.
Oh, there you go.
Okay.
They usually throw the name up there. They heard you, Dolphin. They're like, oops, our bad.
Good.
Didn't put his name up there yet. They're good about putting the names up there, so I do like that about them. Sometimes it takes them a minute, though.
I hope he's not going to get brand new with these text messages either, because, yeah, you were in the group, you know.
Right.
All set, Mr. Nady.
Thank you, Ronald. Sir, have you reviewed that entire document?
Yes,
Does that look familiar to you?
yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years. Definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes.
So as of January of 2022, you would have had a passcode to get into your phone, correct?
Correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to...
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, a date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay. And what you type...
I have a different copy.
Oh, I'm sorry. It's, for the record, it's on page...
What's the bottom page number?
She's all like, let me see that. I need to make sure it's real. I need to make sure if you're real, ma'am.
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
It could be. I have no memory of actually typing it, but
sure,
that's not something. It could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
I don't think it's necessary. Yeah. So let's not, if he recognizes it, I don't want to put names out.
Oh, I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes...
Why don't you refer to the last 2 digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment?
Yes.
Yeah, of course. Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
yeah.
Of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And With regard to 9-3, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
Just one more question for you, sir. Does the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Morning.
Good
afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right. So, sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay. Thank you.
Your Honor, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right. Sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right. Thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So, sir, you can leave.
Okay. Thank you.
All right. And thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
All right. We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I've got to respond to the
No,
objection.
I want to hear you as to why this is admissible. Why this is admissible.
That's fine, Your Honor. Just have a moment.
Yeah, I've got that supplemented list, Frank, that with those 4 added on witnesses.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it. And nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rule of Evidence 901B1-4. Evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid, black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in, again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite. That dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street, or the police get a search warrant and then they show up at a home, and rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites 3 principles. It's almost like they're setting a standard down that the court is supposed to follow with 3 factors. But again, none of the 3 principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has 3 components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you,
All right.
Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it. But there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for 1.5 years. That defeats the purpose of defining the value for which this is being admitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Ms. Giannetti, do you want to respond?
I know we're the hour's late, Your Honor. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice, and we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay. And just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes. It's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Deborah, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
Please.
Well, Bev's got some homework to do.
Well, I'm surprised she didn't have her answer at the ready.
I know, right? She's going to have one decision before 4:30, but she needs a little bit of time on the text messages. Interesting argument, though, there at the end on why not calling Proctor, and it makes sense. It makes sense what the defense strategy right there was. If they may be forced to call him if she doesn't allow this stuff in, but if they can avoid calling him so that the prosecution doesn't lead him, I see it. I get it. I understand that. Now, Higgins is a different story. You got to call that guy. I'd like to hear from Proctor too, but I did understand what they were just doing with that. But for them to say this is hearsay and they can't authenticate it correctly and all this stuff, but you allowed all of Higgins' messages in, his flirtatious text with Karen, all that's in there. And who authenticated that stuff? Karen? Is that how, I mean, this is like,
Didn't Higgins authenticate his own stuff? He was on the stand, right? In the Commonwealth's case? I remember seeing him.
yeah, and he didn't even read his own. In the first trial, they had Higgins come up and read all those messages, I believe.
Hmm.
But in this case, they had, was it Yuri guys that they made read all them? And
Uh,
no,
they
who was
had,
it? Who was
was
it?
it?
They had somebody else read all of those Higgins messages. What was his name? I can't remember. It's on my list over here. It's been
Oh,
a
I
minute.
thought he did read something of his, but maybe not.
Um.
I didn't watch him 100%.
Oh yeah. No, yeah. That. Who was the guy they had up there reading all those damn messages?
I know Yuri read a lot of text messages.
Yeah, he did, and he was also forced to read some of the ones between where Proctor was calling Karen names or whatever, talking smack about her. Yuri. Yeah. Um. Yeah, they shouldn't be forced to call him, right, Rachel? If they can get these messages in, if you got other ones in, you should allow these in. And what did he mean when he said things that could have been deleted and altered, whatever you were leading up to there, my guy? Where were you going with that? Who's going to do that to Proctor? Are you saying the defense got a hold of his phone data and then fudged it to make it look like he sent all these? What are you saying there? Strong accusations, sir. Strange you're going to bring up deleted in the phone in the same sentence when I need to ask you questions about Jen's deleted phone data. Careful there. Careful, sir. Yeah, Yuri Buchanan. Buchanan. He is on the defense list, by the way. They plan to recall him.
Oh, God.
I know. There's a couple people. There was a few people they have on their list to recall that I was like, oh, really? Well, that would be interesting, but okay. I hope it's, worth it, but we'll see. They want to call him up and get their shot at him. I don't blame them, especially if there's particular testimony they testified to. They really want to challenge going, when they're presenting their case. So I'm looking forward to see what kind of questions they do have in line for some of these witnesses they plan to recall that have already testified. So I've kind of gone back over a little bit the testimony of the ones I've noticed they're going to recall to try to get a feel of what they might be trying to hone in on. Um, so you said, Rachel, there was a filing this morning in the case, the prosecution. They're doing that all through the whole process. They've been filing shit that comes out in the morning, and then you got to have a voir dire that afternoon. That wouldn't even be happening over in Idaho. I think that would make Judge Hippler. He would face palm all the time, and he would have everybody's heads on a platter. He already, in fact, he's done made that clear. We're going to get all that out of the way. We're not doing this stuff mid trial. Not happening here. And I appreciate that. So nothing new has come down in that case today or the Stearns case. We're still waiting on decisions over there as well on the 3 motions to keep out the phone stuff, the Google searches and the phone data in that case. No decision made there yet either. It looks like, so tomorrow, I almost said see you guys in the morning, but no, I won't either. It's Saturday morning. I don't do anything on Saturday morning except me time, just relax for a while. But I'll chill out over the weekend. I want to work on some content for a Sunday show. I do want to talk about the Crystal Rogers case and bring some awareness to what's going on there, because I think it's important. She deserves it. Her family deserves a little attention to what's gone on over there. So
Hmm.
it's a really important case, and it's been going on for so long. And the fact that they still have not found her remains, even though we got 3 people on trial for her murder, is just insane. Um, we'll go over what the FBI did a few months back in relation to one of the last searches they did looking for Crystal, and the clues we have seen in this trial that have led up to that search, right? And it's making sense why they went back to the family farm all these years later and began to look around some more. That's because of stuff Steve Lawson told them. And for those of you who don't know, the guy who's on trial right now for conspiracy for her murder, he has cooperated with the prosecution in a sense. There's been problems with that as well, but he does admit to tampering with evidence, meaning I moved Crystal's car and parked it on the Bluegrass Parkway, but that's all I did because Brooks asked me to do that. And there's apparently a lot of more evidence that says otherwise. So I'm putting all that together. Okay, Rachel, thanks. I'll check on all that here in a bit. I got a few other messages I need to check on as well. Do all that this evening. You guys go have a relaxed evening. If y'all come over there and hang out with Miss Shorty this weekend. Yeah, I don't know, Firefly. Good question. Let us know. You guys, Dolphin also mentioned maybe doing it like on Saturday as well, starting a little bit early.
Oh, tonight? Oh.
She's like, tonight?
I mean, well, it's only 4 something now. I mean, yeah.
True. It's only 3:30 for me. All going on 3:30, I should say. Yeah, because she was like, y'all will fall asleep, and we were trying to avoid the falling asleep situation. So, yeah, let us know if you ladies want to do something later. Yeah, I think Publicly Buzz probably has a Sparrow Friday stuff. I don't know what movie they'll be doing over there tonight or anything. Um, it, I'm a little bit all over the place. Sometimes I don't do anything true crime. Well, I take that back. If I just like binge watch TV, 90% of the time it's true crime stuff I'm watching. I don't know. My brain is crazy. But you guys have a good weekend. I will be back on Sunday. I don't know. I might pop in over the weekend at some point, but it probably more than likely on Sunday. I try to spend Saturdays working on content for the week and things like that. There's Joe's link for tonight's live. He was there for jury selection today at Lori Vallow. I guess he'll give an update on that tonight. And her case will start next week. So, all right, guys. I'll let you guys go. Have a good night.
I'll hang back so you can tell me whatever it was you were going to tell me.
Oh, yeah. Yeah. I'll keep checking the dockets in the Stearns case and, of course, Idaho 4 over the weekend. If there's anything that comes down, we'll review it on Sunday. If that comes down tonight, before the end of the day. If not, we'll see what they got on store for us on Monday. You guys, thanks for coming in, and y'all have a great evening, great weekend.
In this here video,
Good night, guys.
please like and subscribe and follow. Much love from Little Yas to each